if I could have you come all the way up here to the witness stand, please. Once you reach it, but before you have a seat, you can just stop and look at me, please. Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth.
Yes, sir.
Please be seated. And once you are seated, if I can get you to scoot that chair all the way forward as far as it will go, can you please state your full name and spell your full name?
Samantha Oakley, Samantha Oakley.
Mr. Agash, you may inquire.
Thank you, Your Honor. Good morning, Ms. Oakley.
Good morning.
Tell the jurors what you do for a living.
I'm a communications operator for the Broward Sheriff's Department.
And what does that mean?
I receive 911 calls, non-emergency calls, and I also dispatch for the police.
Okay. And how long have you been doing that?
I start my 6th year July 3rd.
Back in 2017, is that when you were hired?
Yes, sir.
Okay. Were you working on the day of the shooting on February 14, 2018?
Yes, sir.
Tell the jurors in what capacity you were working.
I was assigned to the 8 Alpha radio system, and I was working as a police dispatcher that day.
So when we listen to the dispatch recordings of what was said back and forth, is that your voice we're hearing?
Yes, sir, for about the first 10 to 15 minutes.
So when the shooter was actually in the building, you're the one working the 911 dispatch, correct?
Yes, sir.
Would you have been receiving any cellular 911 calls that were coming in from students in the building?
No, cell phones, when they call 911, it goes directed to Coral Springs.
And how are you able to get that information when students call in with real-time intelligence? How do you get that information?
They are supposed to transfer the call to our center.
And tell the jurors what a transfer means.
Transfer is when you advise the Coral Springs dispatcher or call taker that you have an incident in Parkland. They are then supposed to say, please hold for the Broward Sheriff's Office. And then they transfer it over to us where all our call takers take the 911 call and send it off.
Now, why would they have to transfer the calls to you? Why was BSO the one responsible for those calls?
A BSO is the one that handles all police for Parkland, the city of Parkland.
Not Coral Springs?
Not Coral Springs. They only handle the fire rescue side.
And this was not a fire rescue exclusive scenario. This is law enforcement.
Yes, from my knowledge, if there's a weapon involved, you send the police first in order for the safety for our police officers, our firefighters, our rescue, to make sure that it's safe for our fire rescue team to enter.
During the shooting, when there's someone actively shooting in that building, were any of those calls transferred over to you at BSO?
Not to my knowledge.
And you're not able to magically get those calls transferred to you, correct?
No, the way we do it at our system, we are assigned to either the dispatch side or the call taking side. So I would have not known any calls coming in. It would just been what was sent to my center.
You do hear when deputies say something over their police radios, correct?
Yes.
And do you recall hearing Deputy Peterson announce possible firecrackers, possible shots fired?
Yes, sir.
Was that the first call that you heard alerting that there was something going on at the school?
Yes, as he was saying that we were also getting a call coming in for me to give out.
Based upon what my client said to you, what do you then do in response?
You notify all of the road deputies and all units to respond. I notified my duty officer to let him know that we had a high priority incident possibly working at the school, and then you just start sending every available unit.
What is the term that you assign to a call that's of top priority like this?
We call it a red call, a high priority red call.
And was it based upon my client's transmission that caused you to label this a red call?
Yes.
And then how does that then lead to a response that's different than just a regular non-red call?
A red call is highest priority. Everybody stops what they're doing and they respond as long as they were not on a previous high priority call as well.
Prior to the shooting, had there been any problems with the police radios, especially in Parkland?
From the time that I was there, no. I know we did have issues when our SROs would be in certain parts of buildings of schools.
Judge, I'm going to object here outside of personal knowledge.
Well, I guess it's speculation. The objection's overruled, but I don't want you to guess. If you have personal knowledge, you can answer the question. Go ahead.
From my personal knowledge, Your Honor, I know that we've had deputies inside of a school that we have had to raise multiple times due to possibly a medical call at the school to make them aware of it, and we have not been able to get them, and then they would have responded, sorry, I had to walk out of the school, or sorry, I had to get reception because of the reception in the buildings.
So this problem with the radio system existed before the shooting occurred, correct?
For my 7 months that I was there that I knew of, yes.
Okay. And were there issues during the shooting with the radio system, to your knowledge?
To my knowledge, yes. Deputies would not hear what I was saying, and also deputies wouldn't be able to hear each other.
Tell the jurors what patching the radio is.
Patching the radio is we have multiple channels, which each individual city has or groups of cities have. And with that, if a city was working an incident to where another city has to work that's on a separate channel, we are able to patch the channels, meaning I am able to speak to both cities or jurisdictions, and they are able to speak to each other and work simultaneously.
So let's say if I'm an officer from BSO and a person is a Coral Springs officer, if the radios are patched, are we now able to hear each other?
Yes, that is how it's supposed to
Can
work.
we pass information amongst each other?
That is how it's supposed to work, yes.
And were the radios ever patched during the time that you were there for 15 minutes during the shooting?
During my time, no.
Did anyone from BSO, higher up, ever ask you to patch the radios?
No.
You don't just decide and do it on your own, even if you think that that's what's best, correct?
No. It has to be a direct order from the highest person that's there. Sergeant, lieutenant, who's the highest ranking officer there.
And if someone had asked you in real time when the shooting's going down, we need you to patch these radios now, were you capable of doing it?
Yes.
Were you willing to do it?
Yes.
Were you able to do it?
Yes.
Tell the jurors how quickly you would have been able to patch those radios if you were asked.
It's 3 clicks of a mouse.
Literally seconds.
Seconds.
Did anybody ever call from Coral Springs? We talked about patching, we talked about transferring. Did anybody just call over to you on a landline or any other way they communicate with you to just give you information, like the shooters in this room, in this building? Did you ever get that?
Again, I wouldn't have known because I was in the dispatch, so I was not physically taking the calls that day. It would have just been inputted into the call that was created.
Did you ever give any real-time intelligence to my client or any of the other BSO first responders as to where the shooter or shooters were located?
No.
That there were any injuries at all in the building?
No.
That there were children who were killed in that building?
No.
If you had ever been given that information, you would have passed that along to the BSO deputies?
Absolutely.
Thank you, Ms. Oakley.
Okay, cross-examination, go ahead.
Ms. Oakley, did you review your statement before testifying here today?
Vaguely, yes.
I'm sorry.
Vaguely, yes, sir.
What do you mean vaguely?
I was able to read it and go over my statement from the deposition that I gave.
Okay.
I didn't memorize it or anything like that, but I did look at points of it, yes.
And that deposition was taken on April 26th of 2022?
Yes, sir.
Now, you were still in training the day that this happened, correct?
I was at the end of my training. We have a period called solo, meaning I've passed all of my tests. I passed the training. My training officer felt that I was willing to or able to do my job. And what they do is they put you on your radio or your position for 40 hours just to make sure that you have it set in stone and you're good to go.
So this was your first 40 hours, basically?
It was my last.
It was your last.
I was in the last 2 hours of my shift for that day, and then I would have been completed for the week.
So were you by yourself handling the dispatch and handling 911 for 40 hours or 38 hours in total when this happened?
Yes.
Okay.
And they also do, they do have a monitoring phase where my training officer does sit at another position and has me handle everything and only steps in if there was possibly something done wrong.
Or steps in if there's a shooting at Marjory, Stoneman, Douglas?
Yes.
Which is-
If I was in the monitoring phase and not signed off on my solo, she would have stepped in, yes.
Okay, but in the solo phase, when everything's going down, actually somebody came over and relieved you, right?
We have something called a TAC dispatcher, which is the tactical alert dispatcher. They sit on a position and they would handle the routine traffic, meaning it was happening in Parkland, so Tamarack and North Lauderdale would have been moved to our secondary channel, and our tactical dispatcher would have taken that channel on 8 Bravo. Due to me only being there for 7 months and the person that relieved me was there for well over 10 years, I felt it when I was told you're moving routine to whatever. I asked her, please take the main channel and I'll take routine, due to my being new and her having the experience.
Got it, okay. And as it stands today, Angela Mize is your boss, right?
She is our regional director, yes.
Okay. Now, you stated that you heard over the radio Deputy Peterson saying shots fired.
Shots fired or possible fireworks, yes.
You didn't know it was Deputy Peterson saying that, though, right?
No, at the time it was shots fired, possible fireworks.
Okay. But my point being is you didn't know, you couldn't differentiate the different deputies'
No.
voices at
No.
that point in time, because you were new.
Yes.
Okay. Now, you stated about the radios out in Parkland. When the officers stepped outside the buildings, the radios, you could hear, correct?
We could hear better, yes, sir.
Now, you heard over the dispatch the word 1200 building, correct?
Possibly.
The dispatch tape would speak for itself on that?
Yeah, yes.
Because all of those calls over the dispatch tape, you would have heard that day.
I have only heard the call from the news. I have never listened to.
No, I'm saying back on that day.
Okay.
If it's recorded on the dispatch, on the A8 dispatch tape, you would have been there hearing it. In
Oh, yes, yes, sir, yes, sir.
Now, the patch order, that can be ordered from the first responding officer too, correct?
Yes, so the way it works is the incident command is the first unit on scene. And then as the higher ranking unit gets on scene, that's who becomes the incident command. So yes, whoever tells me to patch, if they are considered the incident commander at that time, yes, I can patch.
So in a situation where the BSO deputy's on scene for 2 minutes or so, backups responding, they're considered to you an incident commander
Yes, sir.
who could ask for a patch.
Yes, sir.
When the defendant keyed up his radio to speak with dispatch, you could hear gunfire in the background, couldn't you?
I didn't know what it was. I will say that what we hear is a little bit more muffled than the recording. The recording is crystal clear.
Okay.
So I couldn't tell what I was fully hearing for the background noises.
But did you hear something in the background?
I heard
noises?
something, sir.
Ms. Oakley, the moment that we now know Deputy Peterson, but at the time you heard 1,200 shots fired, backup was immediately dispatched immediately, correct?
Yes, sir.
Nothing further, Your Honor. Thank you.
Okay, based on that, any redirect?
No, Your Honor, I have further questions.
Is the witness excused?
Yes, sir.
You may step down. Thank you
Thank
very
you, sir.
much. While she's doing that, you may call your next witness.
You have a brief sidebar?
Yeah. Okay, ladies and gentlemen, I'll give you a quick restroom so we can set up the technology one more time. Same admonition as always, please don't discuss the facts of the case, the evidence, the witnesses, or the testimony amongst yourselves or anyone else till we reach the end of the case. I'll tell you when that is. If you'll just leave those notepads in the chairs and step in the back one moment, I will be right back with you. Thank you. Okay, we're outside the presence of the jury. Everyone can be seated. So the next witness is on Zoom, and then what happens after that?
And we have another witness.
Okay, you're going to get that person here.
I believe he is here.
Okay, but you want to do the Zoom witness first?
Yes.
Okay.
If I can be excused, just to.
Yeah, 5-minute restroom break, and then we'll get the Zoom back up. Secretary, you good?
Yes.
Okay, I'm going to go back on the record. This is State versus Scot Peterson, 19-7166 CF10A. I continue to have Ms. Gomes, Mr. Keller, and Mr. Klinger present for the state. I continue to have Mr. Igarch present with Mr. Peterson, who likewise is present. We are outside the presence of the jury. Defense, the name of the witness.
Is Alexander Wind. Wind.
You all sign on the as well.
Right now. Having Wi-Fi issues right this second. It says that I'm on it, and then it doesn't zoom in. The Wi-Fi is not.
State, are you able to sign on to the meeting?
Yes, I can, Judge.
I appreciate it. Thank you, sir.
If so, can we do that and then put that monitor in front of Mr. Peterson so I can get him on the call?
Yes, sir.
Please, thank you.
Use the phone as a hotspot. That works. Pretty good. I'm very proud of myself.
All right, Alexander Wynn, if you can see me and hear me, can I get you to unmute your sound and turn on your camera on the Zoom call, please?
Yeah.
Sir, you can hear me okay?
Yeah.
All right, sir, I'm going to do this outside the presence of the jury, then I'm going to do it again once I get the jury back in here. Can you raise your right hand for me, please? You swear to tell the truth, whole truth, nothing but the truth?
Yes, I swear.
You can put your hand down. Can you please state your full name and spell your full name?
Alexander Blake Wind, Alexander Blakewind.
Mr. Peterson, are you able to hear Mr. Wynn and see him?
I can.
And Mr. Wynn, were you able to hear Mr. Peterson's response to me, and can you see him?
Yes.
Okay, state anything you need me to address before we bring the jury back in.
No, Judge.
Defense, anything? Okay, please bring the jury back in.
turn the screen off while we share, like so that the jury can't see the Zoom screen while Aaron shares?
There is not.
Okay. In that case, would the court grant me some leeway in refreshing his memory?
I guess we'll just see how it goes.
Okay.
Testifying on Zoom is less than ideal.
Okay.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Once you're back in those same seats, you may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I will give you a moment to get the notepads back out. All right, ladies and gentlemen, when we took our quick break, we were in the middle of the defense presentation. We're going to resume at that point. Again, the next witness will be appearing through the use of the technology. Defense, when you are ready, you may call your next witness.
Thank you, Your Honor. The defense next calls Alexander Wind. Alexander Wind.
Mr. Wynn, can you raise your right hand for me, please? Do you swear to tell the truth, whole truth, nothing but the truth?
Yes, I swear.
You can put your hand down. Can you please state your full name and spell your full name?
Alexander Blake Wind, Alexander Blakewind.
Mr. Iglash, you may inquire.
Thank you, Your Honor. Good morning, Mr. Wind.
Good morning.
Do you prefer that I call you Alexander or Mr. Wind? Up to you.
Alexander is good.
Okay. Alexander, you and I have met once before, remember, when I took your statement? Yes?
Yeah.
And we did it over Zoom, correct?
Yes.
And that's because you were in school at the time, in college, correct?
Yes.
And what school were you going to?
I go to Penn State.
Are you still at Penn State or have you graduated yet?
I just graduated in May.
Oh, congratulations. What was your major?
I studied musical theater.
All right. Hoping to see you on Broadway, yes?
Yeah, that'd be the goal.
Okay. Did you ask me to accommodate you by Zooming you in as opposed to you flying in to be here today?
Yes.
Okay. Now, back on February 14, 2018, just before the fire alarm went off at Marjory Stoneman Douglas, do you remember what classroom you were in?
Yes, I was in the drama class.
And who was the teacher?
That would be Mrs. Hertzfeld.
Do you recall what room she was in?
710.
Is that the same classroom as Ruby and Perry Harris? Do you remember them being in your class?
Yes.
And what happened when the second fire alarm of the day went off in the afternoon?
The second alarm went off, and we sort of stayed in class for a little bit because there had just been one that went off earlier in the day, and we didn't know if it was a false alarm. And then after like a minute or two, we went out. I went out of the class, and then we sort of were facing the 1200 building. And then I remember seeing Greenleaf and Peterson on a golf cart sort of come up to the 1200 building. They yelled. I remember Greenleaf yelling, "Go back, go back," and then turned around to go back to the class. And then I remember hearing the gunshots.
Approximately where were you positioned when you heard those gunshots?
A couple feet outside of the classroom, there's like a grassy area in between my class and where the 1200 building is. I was there.
Can you estimate approximately how close you were to the 1200 building?
Probably about 30 feet.
And when you heard the sounds, did you immediately identify them as gunfire?
No.
What did you think that you were hearing?
I thought a bomb had exploded in the gym.
Did you think it was one loud noise or multiple noises at once?
It sounded like multiple noises.
But your words, a bomb, correct?
Yeah.
And could you tell where it was coming from?
No.
Did you have an idea generally where you thought it might be coming from?
No. I initially thought it was the gym.
Okay, but you weren't sure even of that, correct?
Yeah.
Yes, you were not sure?
Yes, I was not sure.
Okay. And are you familiar with whether there is an echo in the area that you were at?
Yeah, sometimes it could echo.
Explain for the jurors what you mean.
Like if you drop a textbook outside the hallway or something, it would make a loud noise throughout the whole hallway.
What about the configuration of the buildings allows that echo to occur in that area?
It's like a tall building and then an open space and then another tall building. So, yeah.
Did you ever think when you heard what sounded to you like a bomb that the shots were, or the noise was coming from the building in front of you, the 1200 building?
No.
Okay. And did you think that the sound was contained within a particular building or outside, or you weren't sure?
I wasn't sure.
Okay. I wish you the very best. Thank you. We appreciate it.
Thank you.
Cross-examination, go ahead.
Hello, good morning. Can you hear me okay?
Yes.
Okay. So you had never heard gunshots before this day, correct?
Yes.
So you had no familiarity with what an AR sounded like. Is that
Yes.
right? You hadn't taken annual classes where you were exposed to the sound of gunfire.
Yes, that's correct.
And you had never taken a combat lifesaver class, correct?
Yes, that's
You'd
correct.
never taken classes on rifles or how to use them, correct?
Yes, that's
You didn't
correct.
have an annual qualification where you shot off guns every year, correct?
That's correct.
Now, on that day when there was a code red, everybody had a role to play, right? Students were instructed that their role during a code red was to hunker down and find safety, correct?
Yes.
And teachers had a role as well, correct?
Yes.
And the point was that you were to stay put and be safe and wait for the police to come and rescue you. Is that correct?
Yes.
Now, you said you heard multiple shots. It was actually like 6 to 7 sounds, correct?
Yeah.
And you initially thought that it was coming from the gym, but you actually used your common sense and looked over and at some point determined that the sound wasn't coming from the gym, correct?
Yes.
Can you explain for the jury the process you took to come to that common sense realization?
Yeah. So, when I was running back into my classroom, after I heard the initial noise, I sort of thought it was coming from the gym. And then as I was running back, I looked over to the gym, and saw that from my initial thought of the bomb, it was still intact. There was nothing to my eye that would have made it seem like a bomb exploded after I looked over at the gym and saw it.
So you didn't just rely on sound, you also used your vision to confirm with what you were hearing if it made sense, correct?
Yes.
And you knew to do that at what, the age of 16 or 17?
Yeah, I was 17.
Do you remember learning that Officer Peterson, in your words, wasn't doing anything?
Yes.
Yeah, what's the legal objection?
Calls for speculation, calls for legal conclusion, interferes with the...
That's sustained as to calling for a conclusion. Go ahead, Ms. Gomes. Ask your next question.
How would you describe where Deputy Peterson was standing?
At the end of the hallway, the closest to the parking lot of the 1200 building, but sort of still by the 700 building.
And just for clarification, did you see this yourself or was this what your teacher told you?
No, my teacher had told me when we got back into the classroom.
Okay. I have nothing else.
Based on that, any redirect?
Yes.
Go ahead.
The total time that you saw my client, Scot Peterson, was what, a second, maybe two?
Yeah, probably.
Okay. You have absolutely no idea what he was doing when he was on the scene, correct?
Yes.
You don't know who he talked to, you don't know what he was directing, you don't know anything, correct?
No.
Okay. And when you glanced over at the gym, the only reason why you thought it wasn't coming from the gym was because the gym had not imploded, correct?
Yeah.
And when you looked at the 1200 building, was there anything about the 1200 building that would have suggested that there was a shooter killing children and adults in there?
No.
You didn't see any blood or any bullet holes or kids running from the building, correct?
No.
Okay. Again, I wish you the very best in your career, sir. Good luck.
Thank you.
Based on that, any recross?
Just one question, Judge.
Go ahead.
In that moment, were you looking to see if there was any blood or children, or were you just running to safety?
Running to safety.
Was that your number one priority in that moment?
Yes.
Okay, nothing else.
Is the witness excused?
Yes, sir.
All right, sir, you are excused. I'm going to end the Zoom meeting at this point. Thank you very much.
Thank you.
Defense, you may call your next witness.
Thank you, Your Honor. The defense calls Deputy Arthur Perry. Arthur Perry, please.
Sir, if I could have you come all the way up here to the witness stand, please. Once you reach it, but before you have a seat, if you could just stop and look at me, please. Raise your right hand. Swear to tell the truth, whole truth, nothing but the truth. I do. Please be seated. And sir, once you're seated, if I can get you to scoot that chair forward as far as it will go, can you please state your full name and spell your full name?
Arthur Perry, ARTHURPERRY.
Mr. Eiglarsh, you may inquire.
Good morning, Deputy Perry. How are you feeling right now?
It's a little upsetting for me.
Tell us why.
It was a very traumatic event in my life.
Okay, I understand that. Are you okay to help us
Absolutely.
with
Yes, sir.
understanding what occurred and what you did?
Yes, sir.
All right, if you need a break, you let us know, okay? How long have you been a deputy?
28 years.
All with Broward Sheriff's Office?
Yes, sir.
And on the day of the shooting, where were you assigned? What were you doing?
I was a school resource officer for Park Trails Elementary in Parkland.
And how many students were at that school?
During that time, that ranged between 1,000 to 1,600 children.
And let me ask you this. Did you ever wear a bulletproof vest on campus?
No.
How come?
First of all,
Judge, I'm going to object to relevance.
No, the relevancy objection is overruled, sir. You may answer the question.
it's very hot in South Florida. We spend a lot of time outside. It's very hot. It's very uncomfortable. It's very bulky. And the sheriff's office had a policy that we could sign a waiver if we didn't want to wear a vest. We could sign a waiver, not wear a vest.
Okay. I mean, did you take a risk that there could be a mass shooting at your school and then you wouldn't have a vest on?
Yes.
Okay, but that was a risk you were willing to take, correct?
Yes.
You knew my client also prior to the shooting, correct?
Yes.
Tell the jurors about your interaction with him.
I knew him because he came up to Stoneman Douglas High School. He was assigned there. I was at Park Trails before he was ever assigned there, but
Are those schools that are close to each other?
They're a little over a mile apart.
Okay, so both in the Parkland jurisdiction?
Yes, sir.
Okay, and tell us about your interaction with him.
I would assist him if he ever needed assistance on his campus. I also worked detail with him. Every football at home Stoneman Douglas, I'd work the detail with him.
Okay, so you had a bunch of interactions with him, yes?
Yes.
How would you characterize his professionalism, the way that he did his job?
He was very professional. He had a good rapport with the kids. He was an excellent deputy. In fact, I think his school, he had the most arrests out of any school because he was very proactive on campus.
Was there ever a time in your interactions with him, either at school or any of the details, that you saw him wearing a bulletproof vest?
No, I don't believe he wore a vest either.
Okay. What first alerted you to the fact that there was something going on the Marjory Stoneman Douglas campus?
I was at my school. We were conducting dismissal, and it was a little after around 2:20 or so, and I heard on the radio, shots fired. I think we have a shooter on campus, something, that's not exact word, but something of that nature.
And did you recognize the voice?
Yes,
Who was that?
Scot Peterson.
And was that the first time that you learned that there was something going on the campus?
Yes,
Were you going to go to the campus absent hearing his voice on that radio?
no, I had no reason to go to that campus.
Okay. So what do you do when you hear Deputy Peterson make that announcement?
Well, I was standing next to my car because we were conducting dismissal at my school. I opened up my trunk. That's where I kept my vest. I put my vest on. I also had my patrol rifle. I grabbed my patrol rifle, 2 magazines, and I threw my patrol rifle in the front car, and I ran lights and sirens down to the high school.
It may be obvious, but why did you then put on your vest?
Well, if there's shots fired, it's common sense that at that point the vest is actually going to assist me.
Okay. So how long does it take you to get to the school?
I made it to school, I estimate, less than 90 seconds.
Okay. And where do you go when you arrive?
When I get down, my school is on the corner of Trails End and Pine Island. So I went west on Trails End, south on Pine Island, and then I made a right on Holmberg, and I went west again on Holmberg.
Okay.
And by the way, when an officer announces shots fired or possible shots fired, is that consistent with your training? Are you supposed to do that?
Yes, sir.
Is there anything in your training that says you should wait and not let everybody know?
No, sir.
Is it also consistent with your training as a school resource officer to order a code red right away?
Yes, sir.
And for what benefit does a deputy order a code red? Whose benefit is that for?
Everyone's benefit. So the staff and the students can know they have to lock down, okay? And not only do we lock down the classroom, but we have to lock down the whole school. There's no movement in and out of the inner or outer perimeter of the school because we don't want outsiders coming onto the campus.
Okay. Let me approach with what is Defense Exhibit F. If you can show us where it is that you arrived initially.
I arrived at this location right here.
Okay, so for the record, is that north of the campus?
Yes, sir.
All right. And then where do you go from there when you arrive?
When I first arrived,
You gonna need the board to do it? Are you gonna?
I don't know eventually, but
Okay.
when I first arrived, I got on scene and Sergeant Goolsby was there.
Who was it?
Sergeant, he was a detective at the time, but he's a sergeant now, Sergeant Goolsby.
Goolsby.
Goolsby,
Yeah.
yes, sir.
Okay. Yeah.
So I get out of my car and we meet up and we go to the fence, and the fence is locked, okay?
Up to that point, by the way, other than hearing my client say possible shots fired, you're monitoring your radio, correct?
Yes.
Did you have any real-time intelligence that there was a specific location that you needed to go to?
No.
Did you know that anybody was injured?
No.
Did you know anybody was killed?
No.
What happens next?
As we're coming up to the fence, I hear about 3 to 5 rounds go off very, very fast, okay?
When you say rounds, did you recognize?
Shots fired.
Did you know them to be shots fired?
Yes, sir, I recognize them as shots fired.
All right. What do you do with that information?
Well, I'm trying to figure out where they came from, and I'm scanning the area to see if I can see a shooter.
You didn't just run right into the 1200 building?
I had a locked fence in front of me. We have to get through that locked fence.
Okay, let's say you get past the fence. Would you have run right into the 1200 building?
No, because I had no idea where the shots were from.
From the sound alone, first of all, could you tell whether they were contained inside or outside?
They definitely sounded like they were outside to me.
I want you have you use the map and include every possible place that you thought the shots could have been coming from, okay, when you hear those shots. And by the way, do you ever hear any additional shots after that?
No, sir.
Okay, so we're talking about just the initial, you said 4 to 5?
3 to 5.
3 to 5? Okay. So if you can, using your finger, kind of tell us what was in play, what areas were in play.
This whole area here, this area, and all through here. Basically, 3/4 of the whole campus.
So 3/4 of a 45-acre campus?
Yes, sir.
And so you begin to start looking for stimuli, correct?
Yes, sir.
And that included,
Listening to your radio intently, correct?
Yes, sir.
You're also looking, correct?
Yes, sir.
Was there anything as you're scanning the campus and you're looking, anything that jumps out at you, like smoke or blood or gunshot bullet holes, anything like that that you can see?
No, sir.
So what's the next thing that you do, sir?
On the gate, the lock was inside, so Sergeant Goolsby is pulling the lock towards him so he can use his key to open the gate. And then Sergeant Heinrich, he was a school resource deputy at the time.
Yes.
He was in the parking lot with a student, and he jumps up in between cars and says, "Don't shoot. I'm an off-duty officer." Now, I know who he is, and he knows who I am, because we're both school resource officers, and I've worked the football detail at the high school for about 13 years, and his wife was the athletic director there, so I would see him all the time at the football games. And I got on my radio, but it took several times. I kept trying to key up my radio. I eventually was able to announce we have a student shot, so dispatch couldn't, but it took several times. I kept getting this bong, bong, bong.
So you were delayed in making that reporting about someone being shot, correct?
Yes, sir.
How many attempts do you think you made before you were able to transmit that intelligence?
At least 5 or 6.
Let's talk about the radios. Prior to this incident, how were the radios working?
We've always had issues with the radios in Parkland. Where my school is, it's located on the north end of the city, and I've always had problems trying to key up. There's certain areas you can't go to because the radios didn't work.
And what would you do if you're surrounded by, let's say, cement? What would you do to try to be able to get better reception, either hear things better or be able to transmit better?
You have to move to an area where you're getting reception,
Okay.
so you have to move away.
Did you alert people higher up to let them know that the system wasn't working properly prior to the shooting?
Absolutely. Being a school resource officer was kind of tricky because we had 2 sets of command. We had the district office command, and then we had the command that ran the school resource officers. So we would have, every 2 weeks, we'd have a meeting, and we would tell the command from the school resource officers that, hey, our radios aren't working, and the city of Parkland, Captain also knew we had radio difficulties. So it was well knowledge that we had difficulty with radios.
No deputies get to pick which radio system they use, correct?
Correct.
Do you have to use the one assigned by higher-ups?
Yes, sir.
And why is it important to have functioning radios as deputies?
Because we have to communicate to each other. Without communication, we don't know what each other are doing.
And what are you trained to do when you don't have the use of your radios, or are you even ever trained in that scenario?
Yeah.
I could have asked it better.
Compound. One
Yeah.
question at a time. Go ahead, sir.
Have you ever been trained where you have broken radios, where you can't use your radios?
I cannot recall any training.
Hold on a second. That's 2 questions again.
Okay.
One question at a time. Go
Have
ahead.
you ever been trained where the radios are malfunctioning?
I have never received any training through our training department where we've done an exercise without radio communication.
Okay. So tell us what happens next. You are with Goolsby and you encounter Heinrich.
I see Heinrich, and again, like I say, I know who he is, he knows who I am, and he tells me he has a student shot. Unfortunately, he doesn't tell me where the shooter is, who the shooter is, how many shooters there are, where he was last seen. He gives me no information. And I'm trying to key up on the radio, and at that point, Sergeant Goolsby gets the gate open. So at that point, we just run past him and start heading towards the school campus.
Did there come a time where you learned that Sergeant Heinrich, you knew him from Coral Springs, correct?
Yes, sir.
Did there come a time where you learned that Coral Springs had additional information that you guys did not?
Yes, after the fact.
Okay. You learned that they had...
They had all the information, all the 911 calls on the cell phone were going to their dispatch, and we didn't receive any information at all.
And how close were you to Sergeant Heinrich to be able to have that transfer of critical information?
The gentleman behind you with the tie, the gray suit, about that close, yes, sir.
I'm sorry, the gentleman with the red shirt or the prosecutor?
Him, waving his hand, him.
The prosecutor. You were
Yes,
that
sir.
close to Heinrich.
Yes, sir. We can make eye contact. We had eye contact.
And you know him,
I know him, yes.
and he didn't give you any information.
No, I was dressed like this, the exact same day. I was carrying a patrol rifle. There was no question who I was and what I was there to do.
What happened next?
Sergeant Goolsby and I proceed up through the parking lot onto the campus looking for the shooter. I stopped at the last car in the parking lot, and Sergeant Goolsby went to the corner of the 1300 building.
And what happened next?
At that point, I saw Vice laying outside of the 1200 building on the concrete.
Okay. Let me show you what I've shown the state already as Defense Exhibit P, and ask you if you recognize what's contained in this photograph.
Yes,
Tell the jurors what that is.
that's me behind a car, Captain Jordan, the 1300 building and the 1200 building, in the parking lot of the school.
Does that fairly and accurately depict where you were positioned in the parking lot in relation to the 1200 building?
Yes. I've never seen this photo before.
Okay,
I've never seen that before.
but it's accurate, correct?
Absolutely, yes.
Okay. Judge, at this time, we move what's been previously marked as Defense Exhibit P into evidence.
Ms. Wilcox, would it be defense exhibit number 4? State, any objection?
No, Your Honor.
Without objection, defense P for identification will now be in evidence. That is defense exhibit 4.
I'm going to show the photograph to the jurors. Tell us what we're about to see. When was this and what were you doing?
Well, this was sometime into the incident, but at that time, I'm scanning to the west because when I came up on, first of all, let me point something out. When I came up on that car and I knew we had a student shot at the beginning west of me
How did you know that?
because Heinrich told me I got a student shot and I announced it on the radio.
Did you know that prior to seeing Heinrich and being right there with him?
No,
So you hadn't learned that there was any injuries over the BSO radio up to that point,
no,
correct?
I was the first one to announce that.
Okay. And then what happens?
I got up to the location you
Let's
show.
show them the photograph. Okay.
Okay,
So tell us what we're seeing. First of all, Perry is who? That's you, right?
that's me, correct.
And who is Jordan?
She was the captain of the Parkland office at that time.
And she's right there with you? Those are.
Yes, yes.
And what are you doing behind that car?
I'm taking cover and I'm scanning for a shooter.
And is that what Captain Jordan is doing as well?
Captain Jordan's trying to run the crime scene at that point. She's trying to make phone calls and contact people and run the crime scene.
You said trying. Tell me
Yeah.
what you mean by trying.
Well, her radio wasn't working, and she was having difficulty making phone calls.
And so we're clear. Is this the closest car to the 1200 building?
Yeah, it's the last car in the parking lot coming this way. If you're coming from the 1200, it's the first car.
How close would you estimate you are to the 1200 building?
I'm going to say that's probably 30 yards.
Okay.
And is that do you recognize what's contained in this photograph, which is Defense Exhibit 1?
Yes,
What are we looking at in Defense Exhibit 1?
we're looking at the west side of the 1200 building.
So if you're in that photograph, what you're facing, is this the west side?
Yes,
And can you show us where you saw Aaron Feist? Where his body was?
he was in the general area right here on the ground.
Okay. So he would have been outside of the 1200 building, correct?
Yes,
And you see his body there, correct?
yes,
Do you then just rush into the 1200 building?
no.
How come?
Because when I also see his body up in these windows, can you see that if I touch that?
I could try to zoom it in.
Well, up on the building, up on the windows, I can see gunshots on the windows. And based on my position,
Which windows? Are you able to show us?
it's like right,
You want me to enable the,
I would love that, Judge, thank you.
sir, do you see at the bottom of your screen, is there 3 little lines? Right in the middle, bottom?
yes,
Push those. There you
okay. Now what do I do?
go. Now, you can select the pencil option, you can select a color, and you can use your
Yeah,
finger.
Like right, and I believe it was these windows. I'm not sure exactly which one.
Wait, it's not working. Hit a color, just hit one of the colors. Pick whatever your favorite color is. Okay, good. And now circle with your finger on the screen. There we go.
I believe it was these windows. I could see gunshots in those windows. And based on my angle and the fact that Coach Feist was on the ground, I was believing that the shooter was outside west and he shot that direction at Coach Feist, and he shot in such rapid succession that the rifle raised, and those were gunshots coming from the outside toward the inside of the building.
Now, that turned out to be completely not what really happened, right?
Absolutely, yes.
So you can get it wrong, but it not necessarily be something sinister, right?
Yes.
I mean, up to that point, do you know that the shooter's inside the 1200 building?
Absolutely not. Again, I'm considering myself in the hot zone because I just ran past a student that got shot, and I ran up to the next building, and I see another person shot outside, and I'm seeing, well, it appears to be gunshots on a window up above. So I'm thinking everything is to my west. And unfortunately, when you show me that map and you tell me the point where I'm at, you can't get the vastness of the area. The area is so big and there's so many places for someone to hide and someone to move. It's just impossible for 1 or 2 people to cover that amount of area.
And were there any other stimuli, like any smoke that you're seeing coming out of the building?
No,
Any blood?
no,
No students running out and telling you?
no.
Had you eliminated that there could be sniper fire on the campus?
Absolutely not. Could have been someone anywhere in that campus shooting.
Could you eliminate that there were people running around with guns somewhere on campus?
No, because when we're trained to think always the +1 rule. So like again, when I ran past Heinrich, he didn't even say, is there 1 shooter or there's 2 shooters? He gave us no information, and he had a victim right there, which he had intel that he could have gave us right on the spot to assist us.
Were there other officers other than Perry and Jordan that were taking positions of cover around the 1200 building that you saw?
Well, I'm Perry.
Strike that. Other than you and Jordan.
Eventually, a Coral Springs officer came up in the car next to me, to my east.
Yes.
A Coral Springs officer came up there, and he had his weapon pointed at the 1200 building. When he did that, I focused all my energy on the west side of the campus.
Okay. Did you see that? Do you remember the name of that Coral Springs officer?
I do not know his name, no.
Did that officer go running into the 1200 building as soon as that officer got there?
No.
Did you ever see that officer go into the 1200 building?
No, that officer stayed there the whole time I was there. When I left, he was still there.
And you don't even know the first letter of the last name? No?
No.
Okay. And so how long do you think you remained in a position of cover this close to the 1200 building?
Well, before Captain Jordan ever got there, I was in that position in that car, and Gooseby was over in the 1300 building. I was there for about 3 to 4 minutes, and 3 Coral Springs officers came in and ran by me. Again, they gave me no information whatsoever, and I saw them run into the 1200 building outside the door where Feist was.
Okay.
Okay.
So do you go then running in? Naturally, this must be where the shooter's located, right?
No, because I'm thinking, based on what I saw from those shots in the window, the victim that I ran past and the victim in front of me, I'm thinking the shooter is to the west.
Okay.
And
So what reason are you thinking that they're going into that building other than to go save people and or kill the killer?
honestly, I had no clue, and I had no way to communicate with them. I couldn't understand what was going on.
How were you feeling in that moment?
It was bad because after the fact, we learned that, hey, we've got one crime scene, one incident. We have two different agencies running two different operations that aren't communicating with each other and have two different sets of intelligence. It was a total failure on both agencies, to be honest with you.
Physiologically, how are you feeling? Obviously different than how you feel now because you're calm and we're in a courtroom, right?
Oh, sure.
Describe for the jurors how you're feeling, your energy.
Everything was slowed down. My heart rate was pumping. I was sweating a lot. I was looking around.
Was there any difficulty either seeing or hearing or anything like that?
I did end up having tunnel vision because I later learned that a Deputy Hanks, ran by me and went into the building. And I never saw him. I never saw him go into the building. Never saw him run by me.
So it's possible to be looking and not see something right in front of you.
Yes.
That's
yes,
what you experienced.
Yes.
You're not lying about that, right?
No.
Objection, Your Honor.
Yeah, that's sustained.
So what is the next thing that happened after you and Jordan are in a position of cover by this building? And I don't know that I knew the total amount of time that you were in this position.
I'm just guessing at this point, but I'm guessing probably 35 minutes easy. SWAT ends up pulling up. You see the front of that car that we're behind?
Yes.
SWAT ends up pulling one of their Bearcats up there, okay? And they're starting to take control of the situation. But before that happened, again, I had no information about who the shooter was, what the shooter looked like, anything. Cool Springs starts evacuating the 1200 building, and they're running the kids out past me and out the exit. And I couldn't make sense of that because that's not what we're trained to do. And evac the shooter, we want everybody locked down, and we're supposed to go hunting for the shooter. So the kids end up exiting out that west door, and they ran out to Holmberg and they went west down to West Glades Middle School. And then our SWAT unit comes up, and they start their operation. And they discover that the shooter had left the building, and he had westbound. So the sergeant for SWAT, which is Captain Robinson now, told me to leave my position and go down to West Glades and bring all those kids up to the corner of Pine Island and Holmberg Road.
So even as the kids are running out of the 1200 building, you don't go into the 1200 building, correct?
No.
How come?
Well, because I'm thinking the shooter to the west, and I'm like, why is Coral Springs dumping all these kids out into an open field, an open parking lot, and we have no clue where the shooter's at or what he looks like? I had no information to what he looked like, who he was, she was, how many there were.
So in the 35 minutes that approximately that you and Jordan are taking a position of cover by the 1200 building, did you ever on your BSO radio get real-time intelligence as to where the shooter was located?
No.
How many shooters there were?
No.
Whether there were any victims other than the one you saw?
I
Coach
saw
Feist.
4 victims, okay? I saw Coach Feist, and I saw the student that was shot. But right after the 3 officers went into the building, right? A 4th Coral Springs officer came with Deputy Volpe, BSO Deputy Volpe, and they opened up the door and they took out Chris Hickson and put him on the golf cart and took him out the same way that we came in, and I provided cover while they did that. Then they came back in with the golf cart and they picked up a 4th person that I saw. I don't know where they picked them up at, but they also took that person out on the golf cart by me.
You never went into the 1200 building, correct?
Correct.
When was the first time that you learned that there was a shooter inside the 1200 building?
I didn't learn there was a shooter with victims inside the 1200 building until about 7 p.m. that night when I looked on Fox News on my phone, because there was no communication telling us what was going on.
I thank you for your service. Thank you.
Okay, cross-examination. Judge, can I just have a 2.5 break? Okay, ladies and gentlemen, real quick restroom break, same admonition as always. Please don't discuss the facts of the case, the evidence, the witnesses, or the testimony amongst yourselves or anyone else till we reach the end of the case. I'll tell you when that is. If you leave the notepads in your chairs, just step in the back for me one moment. I will be right back with you. Thank you. Okay, we're outside the presence of the jury. Real quick 5-minute restroom break. We'll be in recess for 5 minutes. So if you're comfortable, you can stay right there.
Okay.
If you want to step down, you can step down.
All right.
Don't talk to anyone about your testimony. It's just like you're on the witness stand. Thank you.
Yeah, I've got that.
You'd like to get Mr. Klinger back and go back to the room. Mr. Kilrain, Mr. Klinger present for the state. I continue to have Mr. Igarsh present with Mr. Peterson, who likewise is present. We are outside the presence of the jury. The witness remains on the witness stand. State anything you need me to address before we bring the jury back in and begin your cross-examination.
No, Your Honor.
Defense, anything you need me to address?
No, Your Honor, thank you.
Do we have another witness after this witness, defense?
No. We'll need to drop that.
Okay, I'll do a sidebar when we're done with that witness. Okay. Okay, please bring the jury back in.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Once you're back in those seats, you may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I'll give you a moment to get the notepads back out. All right, ladies and gentlemen, when we took our quick break, we had just concluded the direct examination of the defense witness. We're now going to turn to the cross-examination. The witness remains on the witness stand and under oath. Mr. Kilroy, when you are ready, you may proceed.
Thank you, Your Honor. Deputy Perry, talking about your training. You're taught in training that there's a difference in an active shooting situation between when shots are being fired and when you no longer hear shots, correct?
Yes, sir.
And when shots are being fired, you run towards the sound of the shots.
Yes, sir.
And when shots are not being fired, you look for additional stimulus, gather intelligence to see what the next steps are.
Yes, sir.
Now, you were on this scene for mere seconds while you heard shots, correct?
Approximately 30, 45 seconds, yes,
30
sir.
to 45 seconds, you're on scene, you hear four to five shots,
Three
correct?
to five shots.
Okay. So you weren't on scene for 4.5 minutes during the shots.
No, sir.
You didn't hear 70 shots being fired, correct?
No, sir.
Okay. I'm going to show you what's in evidence as states 1, Your Honor. This can be shown. Deputy, do you recognize what campus this is?
Yes, sir. That's Stoneman Douglas.
All right, Your Honor, may I use the annotator? So just like before with Mr. Aguilar, she can mark. When you arrived on scene, approximately where did you stop your car?
Erase. How do I erase it?
I got it for you. Go.
I was on Holmberg Road, and the left-hand turn signal to turn into the parking lot. Just go up a little bit with my fingers.
Understood.
I got a fat finger.
So this, I'm going to mark it.
On
This
the left-hand.
left-hand turn.
Yes,
Okay.
yes, right there. Yes, sir.
You stopped your car there.
Yes, sir.
That's when you hear the 4 to 5 shots.
No, not until I got down towards the gate. You see?
You can draw to where the gate is.
Right here, that's the gate that was locked.
Okay. So when you get to the gate, that's when you hear the 4 to 5 shots.
Yes, sir.
Coming from the south, but you don't know exactly where to the south.
Well, I wouldn't just say the south. It could have been, can I try?
Show me.
That could have been even all this area.
Okay, so southwest of you.
Yes, sir.
Okay. Now, in training, you're taught to go to the sound of gunfire, correct?
Yes, sir. We know
Okay.
where it's at.
Well, we'll get to that in a second.
Okay.
Now, you approach, I'm going to change it to purple. Once the gate gets opened, where do you and Goolsby head towards? Or I guess Sergeant Goolsby head towards?
We come through here, and I stop at the last car right there, and Goolsby comes up to this location right there.
Okay. Did you go behind it? I'm just going to mark in blue. Did you take this route over here, or did you take the purple route that you marked?
I honestly can't remember. I'm thinking is the route I marked, but
Okay.
I can't be sure.
Okay. Now you're heading towards the area of where you think the gunshot could have come from, correct?
Yes, sir.
You're not just standing there.
No, sir.
You're complying with your training that you go towards the sound of the shots, right?
Yes, sir.
Okay. Now you weren't dropped off in a golf cart right outside where the shooting was occurring, right?
No, sir.
You actually had to run through a parking lot.
Running-
Jog. just
Let's say
move.
jog. I don't run anymore.
Move
I
through a
do-
parking
yes.
lot. Okay. Now, you spoke about you don't wear a bulletproof vest,
Yes, sir.
and are you wearing one today?
Yes, sir.
Okay. Just talking about 2018, you could sign a waiver,
Yes, sir.
and that's the only way, as a BSO deputy, you are authorized to not wear a vest.
Yes, sir.
Okay. And you said on direct, it's a risk willing to take.
Yes, sir.
So if a school shooting should happen at Park Trails Elementary, that's a risk you were willing to take not wearing the vest.
Yes, sir.
Now, on direct, you testified about locking down the whole school. In training, if you hear shots fired, that's the priority, right, to seek out the sounds?
Yes, sir.
Locking down is one
Secondary.
of the secondary.
It's a secondary item, yes, sir.
Now, over dispatch that day, did you hear, you know Scot Peterson, you've known him for years, right?
Yes, yes.
You know his voice.
Yes, sir.
Over dispatch that day, how many times did you hear Mr. Peterson say 1200 building?
I don't know if I ever heard him say the 1200 building.
Did you hear his voice over dispatch?
Yes, I did.
How many times? You can estimate for me. How many times do you think you heard his voice over dispatch?
Well, I heard it when he initially put the call out, and then I heard it when he asked me if I knew where the shooter was at.
Okay.
Those are the two times that I can distinctly remember his voice.
So basically, in the beginning, while the shooting first starts,
Yes.
and then well after the shooting.
Well, I guess not well after. I mean, what do you mean by well after?
After the shooting had stopped for at least a minute or 2 minutes or a few
Maybe
minutes.
30 seconds at best.
30 seconds, okay. When you heard the call, Perry, does he know where the shooter is? How long would you estimate you were on scene for?
Minute to a minute and a half, I'd say.
So 3 minutes doesn't sound right to you?
It's hard to estimate under that type of stress, sir.
Understood.
I'm guessing at this point. I really don't know.
Okay. If it was said 3 minutes later, does that sound preposterous, or could it be?
It could be. I really don't know.
Okay. Now, that day, you also called out dispatch. You used your radio, correct?
Yes, sir.
Juliet, you're 17 Juliet 4,
Yes, sir.
and you reported responding,
Yes, sir.
and you were doing that on your way as you were driving?
I actually tried to say I was responding at my school, but I could not actually get on the radio till I was halfway to the school to let them know I was responding.
Okay.
Because I was having difficulties the whole time.
But you were able to get through that you were responding?
Eventually, yes, sir.
Okay. And do you recall saying something to the effect of Holmberg is shut down, we're by the 900 building or 1300 building, we've got shots fired, I'm trying to get the fence opened?
Yes, sir.
Do you also recall saying parents said there's a child down, have fire rescue staged in the area until we make contact?
Yes, sir. That was Sergeant Heinrich.
So Sergeant Heinrich, you called him a parent.
Yes, sir.
Earlier you said you know him,
I do.
but you said parent.
Yes, sir.
Why?
Because he's dressed in athletic clothes, shorts, T-shirts, and he has a student. He's not dressed in police clothes. So I actually thought he had his own son with him. I actually thought that was his own son he had with him. But someone coming in, if I say off-duty, they're going to think somebody possibly in uniform. So I called him a parent because he is a parent because he has a child at that school.
Okay. So is your testimony today that you and Jeff Heinrich personally know each other?
No, we don't personally know each other. I know who he is and he knows who I am.
You sure he knows who you are?
He's talked to me many times when I've done that detail at the football game. I would hope he knows who I am.
The detail at the football game, how many years?
I did that detail for about 12 years.
12 years. Did you work that with Mr. Peterson?
I've worked some with Mr. Peterson and the deputy before him, yes.
Okay. Are you friends with Mr. Peterson?
Yes, I am.
How long have you guys been friends?
Probably since he started working at the high school.
Socialized together?
No. We have done a couple things together, but I don't really socialize with him.
What do you mean, couple things?
We've gone on 2 motorcycle trips. Okay?
Okay.
And I helped him pack up his house when he moved, and I also, with another friend, delivered his motorcycle to his current residence where he's at.
Okay. And now you were asked on direct that you didn't run right into the 1200 building, and you said because you had no idea where the shots were coming from. Correct?
Correct.
Okay. In training, you're taught to seek out to gather intelligence. Correct?
Yes, sir.
And that's why you ran down the purple
Yes, sir.
track, correct?
Yes, sir.
Stopped at that car,
Yes,
correct?
sir.
Goolsby's down in the corner of the 1300 building
Yes,
in the
sir.
northeast corner. You can see Aaron Feist outside, you said, right?
Yes, sir.
You saw bullet holes in the 1300 building, you said.
Yes, sir.
You saw Coral Springs running into that building.
The bullet holes in the 1200 building.
Yeah, 1200.
Okay. Yes, sir.
You heard gunshots.
Yes, sir.
You still didn't go in the 1200 building.
No, sir.
How far would you estimate you were when you were standing by that car to the 1200 building?
Again, I believe I already said it was approximately 30 yards.
But no shots were being fired while you're there.
No, sir.
Did you hear it called out the radio, stay back 500 feet?
No, sir.
Now, you testified that you thought that the shooting was to the west. You circled it actually in the green area, correct?
Yes, sir.
But you went over just north of the 1300 building, right? Where the trail ends, where the track ends near the car?
I was in the parking lot. Yes, sir.
Okay. You didn't seek out, you didn't go to the football field or the baseball field or the tennis courts, correct?
No, sir.
Now, you said that when Heinrich ran past you, he didn't say anything to you, right?
No, Heinrich didn't run past me. Heinrich was in the parking lot. Can I put a little marker?
Yeah, absolutely. I'll clear this. Hold on.
the-
It'll make it clear. Hold on.
And this is just a general area.
And that's fine. Okay, there you go.
Heinrich was kind of like in this area between the cars.
Okay. And he was going past you with an injured student.
No, he was in between the cars hiding, and he popped up and identified himself.
So he wasn't running northbound to the fence.
No,
Okay.
he was in between 2 cars stationary.
Did he have a student with him?
Yes,
Okay. And what was he doing with the student?
they were stationary, and I told him, as Goolsby and I started coming into the, into here, I told him to get down because the shots were fired.
The student that he was with, did you see the injury that he suffered?
No, sir.
So you didn't see that his foot was almost blown off?
No, sir.
And but your testimony is he was with a student and he was just standing in between.
He was in between, he was, when we first got to the fence, I didn't see him. But he popped up and identified himself. I said, I'm an off-duty corporal's officer, and I know who he was because, again, his wife worked at the school, and I used to see him at the football games when I do details there.
Now, in training for BSO, you're taught that if someone is shot, that you have to provide treatment to them, correct?
Yes, sir?
Providing treatment wouldn't just be standing behind a car, though, hiding, right?
Are you referring to me or him?
In general.
I have no clue what he was doing. I was going towards the shot because that's what I'm trained to do. In that situation, we have to run past kids to go find the shooter.
Now, on direct, you were asked, Heinrich, that he didn't relay any information to you.
No,
Did you ask him?
I didn't have time because I was trying to communicate on the radio, say, listen, I've got to let communication know we have an injured person here. And by the time I was able to actually get on communication, Sergeant Goolsby got the gate open and we started progressing into the school. So at that point, I just ran past him with the goal of trying to go locate the shooter.
So it was more important for you to queue up your radio than to gather real-time intelligence from Heinrich, who you knew to be an officer.
He wasn't giving me any information.
Did you ask for it?
No, I did not.
After that, you saw Coral Springs ran by you and ran into the 1200, and you didn't know why.
Yes, sir.
That's the same 1200 where Aaron Feist is outside,
Yes, sir.
that there's bullet holes in the window,
Yes, sir.
that Deputy Peterson has called out 1200 building 4 or 5 times.
Objection, assumes facts not in evidence.
No, that's overruled. Again, ladies and gentlemen, what the lawyers say is not evidence. You all will decide what the evidence is in the case. Go ahead, Mr. Kilroy, ask your next question.
Aaron Feist outside,
Yes,
bullet
sir.
holes,
Yes, sir.
dispatch calls about 1200 building. Let's see what else we got. Coral Springs running by, and you hearing gunshots.
Yes, sir. And if you read the dispatch logs, you'll also see that I referred to that building as the 900 building. I didn't know that was a 1200 building. I referred to that building as the 900 building.
You didn't run into the 900 building then either,
No, sir.
even though all that stimuli was there.
Yes, sir.
At 223, you're saying you did not hear over dispatch shots fired 1200.
I don't recall hearing that. No, sir.
Okay. And at 224.13, you did not hear we're talking about the 1200 building.
I cannot recall saying I heard that. No, sir.
And at 225.19, Deputy Peterson, we're talking about the 1200 building. You're saying you didn't hear that either.
No, sir. I can't recall hearing that.
Okay. And at 225.58, you didn't hear by inside the 1200 building.
I can't recall hearing that too. I remember hearing Holmberg Road, and I remember seeing units on Holmberg Road, and that's where I proceeded to.
You heard Holmberg Road over it.
I heard, again, I'm having problems with my radio. Even at my school where I normally am on a good day, the radio doesn't function properly, okay? And I'm trying to key up to let them know I'm 51. And what happens when you're trying to key up, you're stepping on people, and you're not hearing what's coming across while you're trying to transmit.
Okay. The first call you heard was the shots, we have shots fired. Be advised, we have possible, could be firecrackers. I think we have shots fired, possible shots fired, 1200 building.
I heard, not all of it, but I heard part of it, yes.
And then you testified earlier that the only other one you heard was Perry. Does he know where the shooter is?
I heard that. I heard bits and pieces of other things.
Oh, now you heard bits and pieces of it.
No, I heard Marchese saying we have a student caught in the fence. What else did I hear? I heard Kratz saying that shots fired by the football field, kids are running westbound. I wasn't getting a lot of communication on my radio.
But you heard football field.
Yes, I
You
did.
just didn't hear any of Deputy Peterson saying 1200 building.
I don't recall him saying the 1200 building, no, sir.
Those are the only two that you recall from Deputy Peterson.
Yes, sir.
So you don't hear 224.14, we're talking about the 1200 building. It's going to be the building off Holmberg Road.
I heard Holmberg Road. Again, I told you I was hearing bits and pieces of things.
Okay. Did you hear shots fired being mentioned about 5 or 6 times?
I don't understand your question.
Did you hear shots fired being mentioned 5 or 6 times?
On the radio?
Yes.
I don't recall.
So once again, you don't recall hearing Deputy Peterson's dispatch, your friend.
I don't,
Objection,
What's the legal objection?
compound question, argumentative.
Well, as to both of those, it's overruled. Go ahead, sir. You can answer the question.
what time are you talking about when I asked if I heard shots fired when you're referring to that question?
No, I'm saying you didn't, besides those 2 that you testified to, those are the 2 that you heard from Peterson, you didn't hear any of his other communications where he mentions the 1200 building.
I can't recall those. I heard shots fired from Kratz, I believe. But I can't recall those situations, no.
And he's your friend.
Yes, sir.
Now, you talked about it's important for the radios. When you're with Goolsby, coming down with him, heading south, you guys are communicating, right?
No.
You're not.
No, he didn't. At a point, he didn't even know I was behind him at one point. He went in and I went in right behind him. And so he's running probably 10 yards ahead of me. And as he's moving, I'm moving.
So he's almost physically communicating with you. By you following him. You're seeing where he's running, so you're following him.
If you want to call it that.
Because
yeah.
you can physically communicate. You can give hand signals.
We weren't giving hand signals. He ran in and I ran after him because I was his backup.
But you could give hand signals,
He would have to look at me for me to give him hand signals,
just
yeah.
in general.
I suppose so.
Okay. When you're at the car with Captain Jordan, you're communicating with her?
I was talking with her shortly, yes.
Okay, so you were able to communicate even without the radios with her?
Yes, because she was like right here.
Understood.
I could touch her.
Okay. And this is, you said you were in that position about 30 minutes?
30, 35 minutes. I'm guessing.
Okay, that's
You know,
fine.
I'm guessing.
Captain Jordan arrives at what time? How long were you in that position when Captain Jordan arrived?
Again, this is a guess. I'm going to say maybe 10 minutes.
And during those 10 minutes, or during the time that she's there, no shots fired?
No, sir.
Did you know where Scot Peterson was at while you were on scene?
No.
I'm showing you what's already in evidence. It states 18. You didn't know that he was in that hallway area right there?
No, sir.
Yeah, you said that Coral Springs officers went in.
Yes, sir.
BSO also went in, right?
Eventually, yes, sir.
Well, eventually, but they also went in when Coral Springs the SWAT guys entered, right?
Which entrance are you talking about?
Either west or east.
On the west side, which I had full view of, I didn't have view of the entrance to the east side. I had view of entrance to the west side. 3 Coral Springs officers went in, okay? And then another Coral Springs officer came up with Deputy Volpe, and they took Hickson out of right behind the door and evacuated him on the golf cart.
So Volpe went in.
Yes.
Okay. And did you know that Richard Vandereems went in?
No, sir.
Did you know that Danny Polo from BSO went in?
No, sir.
And Richard Vandereems being from BSO? You didn't know they went in?
I don't even know who he is.
You don't know who he is? Okay.
No.
So you didn't know that with Coral Springs, BSO officers were also making entrance?
No, sir.
Now this, what's now in his defense for, this photograph that was shown to you, the positioning. What time did you get positioned behind the car, approximately?
Right after we made entry into the gate, when you have the dispatch log say we're going between building 900 and 1300,
Okay.
that's where I ended up right there.
So 2:27:50, does that sound about right?
Is that what dispatch says? I
Yeah.
announced it on the radio.
Okay.
Yes.
Now you said on direct, based upon your training, if your shot's fired, that you're supposed to go hunting for the shooter. Do you recall saying that?
I don't know if I used the word hunting. I don't recall.
You don't
So-
recall hunting?
No, I mean,
Okay.
you want to go find the shooter. I don't know if I don't think I've used the word hunting.
Okay. But training says you go after that shooter.
You go try to locate that shooter, absolutely.
And you said you learned that the shooter was in that building, the 1200 building, 7 p.m. that night on Fox News.
That there were victims and the shooter was in at one time in that building, yes, sir.
What time did you stay till the campus till?
I wasn't on campus at that point. I was at the corner of Holmberg and Pine Island, assisting with crowd control because they were trying to get buses to that location to move parents and students away.
And what time were you there until?
I don't really-
Approximately.
I don't remember.
Now, from this fixed position that we're looking at,
Yes, sir.
what other real-time information did you gather from standing there and scanning the area?
I wasn't getting any real-time information at that position.
You could have moved forward, though, to get real-time information, right?
Well, when you're looking at this position, you're not seeing the large area to the west of me, okay? So I could have moved forward, but if I go to the west, no one's checked that area.
You could have checked the area to try to gather intelligence.
I could, but I didn't have a radio to advise anybody where I'm going.
What about when Jan Jordan's standing right next to you?
When she's standing, her radio doesn't work either.
Yeah, but you could have told her I'm going over there, right?
Well, she's my supervisor. She just told me to stay right there. She's the incident commander at that point.
Okay.
She didn't tell me to go check that area.
But your training says that you go towards whatever sounds, and you thought that could have been in that huge area that you circled on the map, right?
Yes, sir.
And you didn't do that
Because I heard no sounds at that point to send me in that direction.
because you have to seek out intelligence, right?
And I also have to listen to my superior and that crime scene.
Okay, so you didn't move because the superior told you not to.
No, I didn't say that. But she never told me. You asked me why I didn't go there. I was never directed to go there. My task of that area was provide overwatch cover, because if I left that area, that gate's wide open. Anybody can come in and out of that gate.
So you had a specific task. You were an overwatch.
I assigned that task to myself. No one gave me that task.
That's okay.
That's what I felt what my task was.
But you took a proactive step to do something, to do overwatch at the gate, to make sure parents don't come in at this juncture, the shooting's over, no more shots.
That's the reason why I didn't move. That's what I felt my best position was at that area.
Understood. But that was something proactive that you were doing.
Well, everyone should be doing a task on a scene.
Everyone should be doing a task on the scene. That's in training, right?
Yes, sir.
In training, are you ever taught to stay in the same position for 48 minutes?
I don't think I've ever had a training scenario that lasted over 5 minutes, so the answer would be no.
Okay. Now, you said Captain Jordan couldn't use the radio either, correct?
Correct.
Do you recall her at 2:31:30 saying, I know we have a lot going on, do we have a perimeter set up right now and everyone cleared out of the building?
I don't recall her saying that.
Do you recall her at 2:32:48 saying 17 Sierra 1?
Maybe.
And do you recall at 2:33:04 her saying 17 Sierra 1, I want to make sure we have a perimeter set up?
Possibly.
Or at 2:34:40 have them set up on the south side of the sawgrass and they can come from the south?
Again, I wasn't getting all those transmissions.
But the dispatch records would show what was
Yes,
said.
absolutely.
Now, you took part in, well, let me ask you this, at Park Trails, do you have Code Red training for the teachers?
Yes, sir.
And do you partake or teach that Code Red training?
No, I don't teach that.
Or do you sit in on it?
I monitor it, yes.
Monitor means you're there in the room.
It's not a room, it's a school. It's done with the Broward County School Board, school police conduct it, and I assist with shutting the roadways off so the kids can cross the roadways safely.
No. The classes, when you learn about Code Red, or when you're teaching, when the teachers are learning about Code Red, do you recall those situations? Those trainings for the teachers?
No, we don't, as a sheriff's office, we don't teach the teachers how to do a code red. That's something done through the school board.
When the school board comes to teach those classes, are you in the room when they're teaching the classes?
No.
And during a code red drill, what is your responsibility?
My responsibility is I'm going to be a liaison with the incident command and the principal in order to communicate what's going on campus.
If you hear shots fired on Park Trails Elementary, what are you trying to do?
I'm going to go try and find and locate those shots.
To protect your kids on campus, the students on campus,
They're not my kids on campus, they're students on campus.
the kids that go to your school.
That's not my school, it's a school I'm assigned to.
And so it's not your school.
No, sir, that's not my assignment.
You're assigned school.
Yes.
Just one moment, Your Honor. So when you saw Coral Springs Officer Heinrich, I'm going to go back to the map. I'm going to zoom in as close as I can to the area that we were talking about. So once you enter the gate here, you speak.
Up here,
I'm sorry. You do it for me. You do it. Sorry.
the gate's up there.
And where approximately, what row of cars were you in when you saw Jeff Heinrich and the kid?
I was outside the gate, I wasn't, Goolsby was trying to unlock the gate when he popped up and identified himself.
And approximately where were you?
I was,
I'm sorry. I apologize. Where approximately was Officer Heinrich? Sorry.
again, this is an estimated guess because I'm looking at an aerial view and looking straight is a whole different view, but I'm gonna guess he was in an area over here.
Okay. Not in an area over here.
No, sir.
And that is while you were still outside the gate before you actually made entry onto the campus.
Yes, sir. Well, as we were making entrance, yes, sir.
And how long would you estimate the interaction with Officer Heinrich was?
Very brief,
5 seconds?
10, 15 seconds.
10, 15 seconds, okay. Your Honor, I have nothing further for this witness.
Okay, any redirect?
Yes, Your Honor.
Go ahead.
Deputy Perry, when was the last time you got together with Scot Peterson?
Whenever he moved out of state,
How many years was that?
4.5 years ago, I delivered his motorcycle with a friend to his house at his new residence.
Have you spoken to him even in the last several years?
No, sir.
Would you ever lie for Scot Peterson?
Objection, Your Honor.
Yeah, that's a stain.
Let's talk about training. You had said that you never had any training scenario last longer than 5 minutes.
Yes, sir.
Describe the active shooter training that you received and whether that compares to the situation that you were confronted with and the other deputies were confronted with.
When we do active training, it's always done in a confined building. And not only that, we've already walked through the building before we do the training. And when training does the active training, they'll take up a yellow tape, whether say crime scene, whatever, and they'll say that area is out of play. That area is out of play. So we may, honestly like a rat going through a maze when we do active training, because they make it so we have to go down a certain hallway. We have to do this because they want us to get to a certain location to address the shooter. So they make it pretty much direct us path by path, a path to where we have to go.
So you're always contained within a building, correct?
Yes, sir.
And you all know the shooter's going to be there, correct?
Yes, sir.
You just have to find him, correct?
Yes, sir.
Have you ever had a scenario that dealt with acres of area to cover?
Objection, asked and answered, Your Honor.
Yeah, that's sustained.
Have you ever had a scenario where you're trained without having the use of your radios?
No, sir.
Objection, asked and answered, Your Honor.
Yeah, sustained.
Now, when you lock down a crime scene, is that consistent with your training at times when you do that?
Yes, sir.
Tell the jurors under what circumstances you're trained to lock down a scene.
Well, any crime scene we have, we're taught we want to make that crime scene as big as possible, because if you make it small, you can't make it bigger. But if you make it as big as possible, you can always bring it in as the situation dictates. But if you have a small crime scene and you realize that this is outside the crime scene, this is outside the crime scene, you can't expand your crime scene because it's already been tampered with at some point.
And what about locking down a school at the time that it was, where parents and kids were going to come on? Is that consistent with your training in a scenario like this?
At Code Red, we locked down school, yes.
Why is it inconsistent with your training to allow kids and parents to come on to a school when there's an active shooter?
Well, because first of all, they're going to become victims. We don't want to bring any additional people into the campus that are wandering the hallways that become a victim.
Is it consistent with your training if there's potential surveillance footage available to be viewed that might show where the shooter's at, to send someone to the surveillance room to look at that surveillance footage?
Absolutely. I work at the airport now, and that whole airport is under surveillance 24/7, 7 days a week. There isn't a place you can't step in that airport without a camera finding you. And that's what we do when we have crimes at the airport. We just look at the cameras and we can see everything that goes on.
Now, do you remember when the prosecutor put a photo up and he asked you to circle where it was that potentially the shots could be fired?
Yes, sir.
Do you remember not even circling as a possibility the 1200 building?
Yes, sir.
And how come you didn't circle the 1200 building?
Because, like I said, I saw fights outside the building, and when I looked up, I saw rounds in the window. So I was thinking that they were shooting west, shooting east.
The prosecutor also showed you this photograph. I'm going to zoom in. Do you know who this deputy is or officer is standing right by my client with his hands on his hip?
I can't make that picture out.
Okay. When you were asked by me how long you were in a position of cover in the parking lot with Captain Jordan, we were talking about this photograph. I want to make sure I heard you correctly. It was, I think you said 35 minutes easy. Do you remember saying that?
Yes, and again, these are all general guesses. You know, when you're on crime scene, I don't even wear a watch. You're not sitting there with a watch seeing, okay, this time passed, this time passed. The last thing on your mind as you go into that thing is trying to process time. So these are just general educated guesses.
So do you believe that you could have been in that position of cover even longer than 35 minutes?
Absolutely.
You had indicated, even on cross, that the first time you learned about shots being fired inside the 1200 building and there being kids and adults killed was on Fox News, correct?
Yes, sir.
Where physically were you when you were watching Fox News and saw that
at,
information for the first time?
I was at the corner of Holmberg and Pine Island doing crowd control with the parents and the students.
And you do recall my client asking you at 2:29 Perry, does he know where the shooter is? Correct?
Yes, because I responded to it.
Okay, so first, what were the circumstances? What was said before that would cause my client to ask that question?
I don't understand your question.
No, it's overall, it's a speculation, but I think the witness said he didn't understand your question, sir. Ask another question.
Do you know what my client meant when he's asking you, Perry, does he know where the shooter is? He. Who is he referring to as he? Do you, if you know?
Yeah, that's sustained. You can't ask him what someone else thought. Go ahead, sir. Ask another question.
What was happening right before my client asked, Perry, does he know where the shooter is at 229? Do you recall?
We're trying to enter the campus.
Okay. And when you hear my client saying, Perry, does he know where the shooter is? What in real time did you understand that to mean?
I think he's asking me a question, asking me if I know where the shooter is.
Okay. And what did that mean to you?
That means that I'm trying to relay real-time information, but unfortunately, I didn't know where the shooter was.
Okay. One final question. Even though you saw bullet holes and Feist down and Coral Springs running in and students running out and all the real-time intelligence that you had, do you still feel like you did everything you could at the level of your awareness as best as you could?
Yeah, that's sustained.
Even with all that intelligence, you still didn't go into the 1200 building, correct?
No, sir.
And based upon what you had, did you believe that you had enough to place you on notice that there was a shooter inside that building?
No, sir.
Okay. Thank you, sir. I wish you the very best, and thank you for your service.
Based on that, you recross?
Deputy, the crime scene is always secondary to finding the shooter, right?
Yes, sir.
Okay. And on, I guess, redirect, Mr. Argalash asked about the circle, the green circle of the campus of where
Yes,
the
sir.
shooting can be.
Yes, sir.
You came in here today and you literally circled the campus except for the 1200 building.
No, I think I only circled like the west half of it. I didn't circle the east part of it because there's a courtyard there and all those classes east.
But even though dispatch, Scot Peterson said 1200 building multiple times, you came into court and didn't circle the 1200 building.
Objection to the compound question and assumes facts that he was not privy to.
No, it's overruled as to both. You can go ahead and answer that, sir. Go ahead.
I think the question you asked me was where did I think the shots were coming from? Is that correct?
Yes.
And I circled where I thought the shots were coming from.
And even though outside the 1200 building you saw Feist, you saw the bullet holes, you
Yes.
saw Coral Springs running in,
Yes.
dispatch said 1200, you still didn't circle the 1200 building.
No, sir.
Now, you testified on redirect that the training at most is 5 minutes,
A lot of times, yes, sir.
a lot of times.
Yes. Sometimes it's shorter.
And sometimes it's 15 minutes, right?
A training scenario?
Yes.
I don't think I've ever been in a 15-minute training scenario, no, sir.
Okay, so you've never had a 15-minute training scenario
Right.
for active shooting, 10 to 15 minutes.
I can't recall anything that fast, no, sir, that long.
When you're speaking about you're making the crime scene bigger, that's in regards to collecting evidence, correct? You want to make the crime scene bigger
Correct?
so that evidence of the crime scene people can come in and collect the evidence.
Correct.
Now, on redirect, you were asked about keeping the parents out. The priority is to get the shooter, though, correct?
Yes, sir.
Every trigger pull you're trained could be another dead person, correct?
Yes, sir.
And you're trained that you need to stop bleeding immediately, correct, to save people's lives?
We need to stop the shooting immediately.
Then you also need to stop the bleeding.
Yes, sir.
Now, you testified on redirect when it was said, Perry, does he know where the shooter is? You presumed when he said, does he know, that he was talking to you?
I don't know, but I answered it. I presumed when he said Perry, that's me, and when he says he knows where the shooter is, I presume he's talking to me, and I answered.
Now, this is immediately, do you recall that this is immediately after Deputy Marchese says 17 Juliet 5, I have a gunshot victim, he's by the entrance of West Glades on the west side of the school? Do you recall that being the dispatch right before the question is asked, does he know where the shooter is?
Again, it was happening so fast, so you're asking me which scenario. I remember Deputy Marchese saying that. I've already testified to that. The order in which it came, I can't say I positively know the order in which it came, no.
The word he, did you think he was asking you, does he know where the shooter is? Or did you think he was asking about the kid who was shot?
I have no clue.
I have nothing further, Your Honor.
Okay, is the witness excused?
Yes, he is.
All right, sir, you may step down. Thank you very much. While he's doing that, can I do a quick sidebar with the lawyer, please? Okay, ladies and gentlemen, I'm going to send you to lunch at this point. I hope the same admonition as always. Please don't discuss the facts of the case, the evidence, the witnesses, or the testimony amongst yourselves or anyone else till we reach the end of the trial. If you leave the notepads in the chairs, they'll be waiting for you when you come back. I hope you have a nice lunch. I'll see you all at 1:40 p.m. in the jury room. 1:40. Have a good lunch. Okay, we're outside the presence of the jury. State, anything you need me to address before we recess for the lunch break? Defense, anything else?
No, Your Honor, thank you.
Okay, so we'll be back, let's just call it 1:45. At that point, I'll address the issue with the witness that the defense is trying to get on Zoom, and we'll figure out the schedule going forward then. I hope you all have a good lunch. I'll see you at 1:45. Present for the state. I continue to have Mr. Aguilar present with Mr. Peterson, who likewise is present. We are outside the presence of the jury.
Yes, Your Honor. As of this moment, unfortunately, we have not been able to reach him. That said, though, we did have some discussion over lunchtime, and the truth is, I'm being candid with the court, at this point, regardless of even if he called in right now, we don't feel comfortable calling him, nor do we believe he's necessary, so we will be withdrawing our request
Okay.
for additional time, and so that issue's been resolved. We have, we will not be calling him.
Okay, so do you have any additional witnesses that you want to put up?
No, I have spoke with my client at length. He has a strong desire to speak with the jurors, but will be taking my advice and not testifying, believing as I do that the state has failed to meet their burden.
And so you have no other witnesses, in addition to your client not testifying, you have no other witnesses?
That's correct. We are ready to rest in front of the jury.
Okay. Okay, so I guess, let me finish my conversation with Mr. Peterson, and then in fact, if you're going to rest, I'll bring the jurors in, I'll let you do that in front of them, I'll send them out of here. Again, I have their phone numbers. If I had to call them off for Monday, I can do so. I'm not prejudging anything. I can hear any renewed motions. And if the case goes forward after that, we can have a charge conference this afternoon. And I would be asking the jurors to be back, say, State, would you have any problem being back here Monday at 9:15? Defense 9:15?
That's fine.
I'll talk to you, again, if we get to that point. I'll talk to you all about how much time you might be asking for closing arguments, but we could do all that on Monday. So, Mr. Peterson, let me put you under oath. You swear to tell the truth, whole truth, nothing but the truth?
I do, Your Honor.
Okay, you can put your hand down. Please state your full name.
Scott Ralph Peterson, Peterson. All
Right, and Mr. Peterson, everything remains the same regarding prescription drugs, any mental health, alcohol, any of those issues since my last discussion with you, which I think was yesterday. All the answers are still the same?
Yes, Your Honor.
Okay. So your lawyer is telling me that based on the what's been presented so far in the defense presentation, that I'm going to have the jury come back in and you're going to rest in front of the jury. So let me finish the conversation I started with you yesterday about your right to testify. You've had enough time to think about it, to talk to your lawyer about it. He's answered all your questions. Talk to your family about it regarding your decision about whether you want to become a witness or not.
I have, Your Honor.
Okay. And again, I'll repeat, you understand, even if it's your lawyer's advice for you not to testify, if you wanted to testify and be a witness, you get to testify. It's one of the fundamental decisions that you get to make. Do you understand that?
I do, Your Honor.
Okay. So understanding all of that and also what we discussed yesterday, have you come to a decision about whether or not you want to become a witness in the case?
I have.
And what is that decision?
I will not testify.
Okay. So I'm going to read the standard jury instruction to them then, if we get to that point. Both paragraphs regarding the fact that they're not to put any weight in that decision whatsoever, that they will decide whether the state has met its burden of proof based only on the evidence, witnesses, and testimony that they have heard. So my intention would be to bring the jury back in. I'll ask the defense to call their next witness. The defense can rest in front of the jury. I'll then send the jurors home, asking them to be back here on Monday, June 26th. I'm going to ask them to be back at 9 o'clock, and hopefully we can get going right at 9:15. State anything else I need to address before we send the jurors home for the day, and we'll keep working, but they won't be here, or any objection to proceeding in that manner.
Just 1 minute. Judge, sorry, we're just discussing one potential rebuttal witness. We just have 1 minute,
Sure.
2 minutes.
Sure.
we won't be calling it about witness.
Okay, so any objection to proceeding in the manner I announced or anything else you need me to address before I bring the jury back in at this point? Defense, anything else that you need to address?
Thank you.
Okay, please bring the jurors back in.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Once you're back in those seats, you may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I'll give you a moment to get those notepads back out. Okay, ladies and gentlemen, when we took our lunch break, we were in the middle of the defense presentation. We're going to resume at that point. Defense, when you are ready, you may call your next witness.
Thank you, Your Honor. At this time, we rest our case.
Okay. All right, so ladies and gentlemen, both the state and the defense have rested their cases. The only thing that remains in the trial is the closing arguments from the lawyers. Then I would be instructing you on the law, and then you would be deliberating your verdicts, and we're going to do all that on Monday. Okay? So the schedule going forward is I'm going to have you out here momentarily. I'm going to ask you to be back here on Monday, June 26th at 9 o'clock. 9 o'clock, and I know you're veterans at this point, but I'll remind you Monday's the busiest day in this building, so allow yourself time based on that. And when I have you back in the courtroom Monday morning, we're going to go right into the closing arguments from the lawyers. After that, I will instruct you on the law, and then you will be deliberating your verdicts. So, same admonition as always, ladies and gentlemen. Please do not discuss the facts of the case, the evidence, the witnesses, or the testimony amongst yourselves or anyone else. Please do not do any research regarding this case, directly or indirectly from any source whatsoever, on the internet, on social media, on your phones. Please do not watch any news. Please do not read any newspapers. I hope that you all have a nice rest of this afternoon back at your normal lives. I hope you have a nice weekend. I'm going to see you all Monday morning, which is Monday, June 26th at 9 o'clock in the jury room. If you will leave the notepads in your chairs, they will be waiting for you Monday morning, and we will conclude the trial on Monday morning. I'll see you then. Okay, we're outside the presence of the jury. Everyone can be seated. Both the state and the defense having now rested their case, and that's the close of all the evidence. Any renewed motions on behalf of Mr. Peterson?
Yes, Your Honor. First, we would renew all motions that we have made throughout this trial and pre-trial, including the motion to dismiss. And now we would move for a judgment of acquittal. Now that the burden is different, it shifts to looking at this case in the light most favorable to the defense. We would renew our motions, and we would maintain again that the state has not met their burden, and they didn't prove each and every element in each and every charge, the 11 counts in the information, and ask that you dismiss this case.
State, I'll count anything you argued with the previous judgment of acquittal argument. If there's anything in addition you'd like me to consider, go ahead.
Judge, now you're off the podium.
Sure.
Well, Your Honor, in the I disagree with defense counsel's statement of the law regarding the second judgment of acquittal. Basically, a second judgment of acquittal, the law is just standard, is just about the same as the first judgment of acquittal, and that is, once again, looking at the evidence in the light most favorable to the state, that reasonable men would differ. They don't really change between the two. The law standard does not change between the two JOAs. So I would ask the court to once again look at the standard today through the same prisms the court looked at the last time. In addition to the argument that I made the other day, Your Honor, I want to go back to a case that this court cited in its order on the motion, on defense motion to dismiss, and that was State versus Christie, CHRISTIE, 939 Southern 2nd, 1078. Now, this court, for the most part, cited that case in order to say that the court was going to go with the standard language of that any other person would be the definition used for culpable negligence for a caregiver versus the defense had wanting the court to use read it in pari-mutuel with another chapter, and the court said no, and the court listed 4 cases where it said in its order, this is why I am going to rule for the state and deny the motion to dismiss. And if you just give me a second, I'll get to your order. And this, this court finds it is not required to determine the disputed or undisputed facts of this case. The determination will be made by the jury based on the evidence presented at trial. In support of this conclusion, this court notes standard jury criminal instructions 16.5 and 16.6, as published by the Florida Supreme Court. Each require as an element of each crime a determination by the jury as to if the defendant was, quote, a caregiver for the victim. In further support of the conclusion, this court notes both jury instructions also include the verbatim definition of a caregiver as defined in 82701, and a copy of which the court attached both the instructions to its order. And at the top of the 3rd page of Your Honor's order, which was filed with the clerk on 8/19/2021, entitled Order Denying Defendant's Motion to Dismiss, the court cites to Christie. The first citation actually is on page 2, and then on the 3rd page, the court in parentheses after the case name says finding a public school teacher was another person responsible for child welfare. So, Judge, if we go into Christie, there's an interesting paragraph to be found inside that case, which reads as follows. We further agree with the state that teachers stand in loco parentis to the students during school hours. A public school owes a general duty of supervision to the students placed within its care. Case law is replete with instances of schools, principals, and teachers being required to reasonably fulfill their duty to supervise students. The genesis of this supervisory duty is based on the school employee standing partially in place of the student's parents. Mandatory schooling has forced parents into relying on teachers to protect children during school activity. So the other day, the court was questioning me regarding the defendant's role as a caregiver, which is one of the elements that has to be found for the statute. And Judge, I would say to this court, it would be very difficult to parse out the defendant's role, the SRO, from the school's teachers and principals and associate principals. They all are there. A lot of times, kids, you go to drop your kids off in the morning at school, and they're all standing out there as you drop the kids off, including the SRO. And I think it would be insane to say that every parent doesn't think in their head, well, I hope they're all going to do their duty today in protecting my child or my children. And the SRO is at the school in the position where he deals with the children. Now, you had asked me the other day about, does he have a duty to all of the children? And I still maintain yes. But on this particular day, I believe he had a more specific duty, and that was to the kids in the 1200 building from 2:15 or so on that afternoon. That was his focus. That's where he went. And it was on that day that he truly owed those kids his role as caregiver. But you can also see from the videos and everything else, he calls the code red. As a matter of fact, in his own statement to Detective Curcio, he says to the detective, is on page 10 of 36, which the statement is in evidence. At the same time, I'm telling Mr. Greenleaf, get out, get away. He's not armed. He's an unarmed person. So I wanted him away from there. So I started to tell him, get out at the same time. I then hit, I'm on school radio screaming, school radio scream, yelling lockdown. Lockdown, code red 2, so you know, so the school was aware to put the school on lockdown, that we possibly have an active shooter. And if the court will remember, in one of the dispatches, we hear the defendant say, gentlemen, lock it down, or lock the school down. And there alone you can see the caregiver relationship itself. Now, I'm going to make a distinction in causation and caregiver, all right? Even though I'm saying he's showing that he's a caregiver, that doesn't mean I'm agreeing that that he doesn't have cause. He did cause or wasn't culpably negligent. But for the purpose of just caregiver, he's fulfilling his role. Now, earlier, and also in the defendant's statement, we find that Detective Curcio asked the defendant, what were you doing in that time period just before you got the first notice that something was wrong at MSD? And what he was doing was actually waiting for the father of a student to arrive at the school. During the lunch break that day, there were some girls in the parking lot. They were in an area they weren't supposed to be in. The defendant wasn't there, but some of the other monitors were. They went over, they looked into the situation, and inside one of the girls' cars, they found a fraudulent ID. And so that was then given to the defendant, and for him to deal with when he had time to deal with it. So he had already called the girl's father and had set up a meeting at the end of the school day with the father and with the girl, because that's one of the things he does. He handles when things go wrong on the campus criminally or crime-wise. That's his duty to investigate and find out what's going on, but he also works along with the students. And that takes us back to that contract that I believe it was Lieutenant Colonel Samaru, who went over the contract between Parkland and the Broward Sheriff's Office concerning SROs. And that, of course, is also in evidence. And what I was just speaking about is in the contract. And I want to go through it in order, so I don't want to jump around. But In the contract under Article 2, Section 2.05, duties of SRO, an SRO shall not function as a school disciplinarian or a security officer and shall not intervene in the normal disciplinary actions of the participating schools. Each assigned SRO shall act at all times within the scope of authority granted to the SRO by applicable law. Each SRO shall perform duties including A, that south end of the school seems to be well secured. No one seems to be indicating that there's anything wrong south of his position. It's all the problems north of it. So, since the court has already ruled that the caregiver needs to be found by the jury, and the state has put out evidence that shows that he is a caregiver, we would ask that the court then go ahead and deny the motion for judgment of acquittal in regard to that area and allow the jury to make that determination. They've got the facts in front of them. They're the ones who will make that determination, and that's how, if you read your own order, that's how the court, it sounds how the court wants it to be. You know, I know the other day the court also had asked questions about cause. So again, if you look at Christie, and almost a lot of the cases that have to do with child neglect, what happened in Christie? What were the facts in Christie? Well, it was that a teacher was charged with child neglect, and the teacher had a teacher's aide. And the teacher's aide was tying up the kids and, I don't know, doing stuff to the kids. And the teacher didn't do anything. Just sat there and let the teacher's aide have a field day. Go ahead. Do what you're going to do. And so, sure, when you abuse a person or child directly, then you get charged with child abuse. But when you have this sort of indirect, this culpable negligence, which you had in Christie, they charged the teacher also with culpable negligence. It was without harm, I guess. It wasn't as bad. The children were injured, but nonetheless, that's how it can be through, I don't know if this is the right way to say it, but it can be through a third party in the sense that you don't actually do the abuse, you don't actually do the injury, but in the background, you're culpably negligent. You're a cause of that injury. You're willful. A disregard ends up in that particular child being injured, and you've done nothing about it. It would be almost as though it's a little bit of an extreme example, but if you're at the beach and your child is out there and in the water, gets caught in a rip current, and you see that, and you see your child struggling, and you stand at the edge of the water and you just don't do anything. You go back and sit down on the sand and sort of just sit there and you don't do a thing. You don't run for help. You don't try to go in the water. You don't do anything. That's a problem. You need to react. And so if the court's initial problem with causation, I think Christie at least helps to answer the fact that, look, you can charge somebody who didn't actually do the injuries. And here in the information it reads, I'll use count 3 as an example. Thereby allowing Joaquin Oliver to be shot and killed with a firearm by another person, and in doing so cause great bodily harm, permanent disability, or permanent disfigurement to said child. And that's, again, through omission, but it also can be through acts. It doesn't have to be just omission. It can be doing things that cause the child to be injured. For example, in this case, when the defendant sets out that perimeter, don't come within so many feet of the 1200 and the 1300 building, he is causing a delay in law enforcement response. Meanwhile, we have up on the 3rd floor Anthony Borges, who's in horrible pain, blood everywhere. You have Stacy Lapel, who's been hit by gunfire. You also have Marian Kampachenko. There are people in that building that are alive and need help, and yet the defendant has called out onto BSO radio something that will slow people down and keep them away, and there's no policy behind that. So it doesn't just have to be omission. It doesn't just have to be, oh, you didn't go in and get the killer. There's more to it than that. And I think the court can see from the information, when we list failing and refusing to attempt to investigate the source of the gunshots, fleeing approximately 75 feet away and then staying there for the remainder of the time, refusing to speak with those 5 students who come out of that building. Now, that brings us to that issue of tunnel vision. If you're looking at causation, you're looking at culpable negligence. I don't think the court wants to be making a decision as to whether or not the defendant had tunnel vision or not, that he couldn't see those huddled kids in the parking lot that Sobley saw, who was walking toward them. It's a decision for the jury. So I think the law is there. The law says, right, culpable negligence, so it could be sort of a person who doesn't do the injury to the children can still be held responsible. All right, and then you move forward. Well, the state has given, tons of facts that indicate that the defendant did not do what we felt he should have done. His training told him to do that day. He doesn't go to those kids in the parking lot. But those are questions for the jurors to decide. And that's why I think that I wanted to make sure today. I know it's a little bit repetitive, but those were the issues that the court was concerned about, and I wanted to make sure they were well covered. And if the court had any further concerns or questions, I'd be more than glad and happy to address them. But again, as I said the other day, there's plenty there to send this case to the jury. Now, looking at the evidence in the light most favorable to the state, we have given enough evidence for the court to be able to allow the jurors to let the jurors make the decision. You've got the law down. Now they need to get the facts down.
And you think Christie supports the position that the person charged under the statute doesn't have to be the person who's committing the harm?
Yes. They're not physically committing the harm, right? They're not. They're in action. And if you look at you cited 4 cases, I believe, and there was 3 others in your motion. But if you go through the case law, there's lots of instances where it's a third party that is being charged with a third. I use that term. They're being charged. A party is being charged with culpable negligence. That whatever they did resulted directly or indirectly in harm to another person.
Okay. Mr. Igar, shall I give you the last word if there's anything else you want to say?
This case can't plausibly be analogized to Christie or even the other ones that Mr. Klinger provided. I may have juvenile clients that I treat as my own children, but they're not my children. They're not legally my children, and I'm not their caregiver. So merely being as wonderful as my client was as a school resource officer and acting as if they were his children doesn't make him his own and doesn't make him a legal caregiver. And secondly, the court heard the facts of this case. It fell way short of the causation that is required to let the jurors hear this case. I'm asking that you grant this motion.
Okay, well, understanding at this point in the proceedings, all the evidence is closed. I'm well aware that it's a different standard. Again, I don't know what part of the evidence, witnesses, or testimony the jury's going to believe or not believe. They certainly, I think, could find that the state has proven the elements of each charge beyond a reasonable doubt, or they may, in fact, find that the state has failed to do that. But that's going to be their decision to make, not mine. So, respectfully, the renewed motion for judgment of acquittal is going to be denied. I will enter the appropriate written order. Next. If we could do the charge conference now, then I could send you out of here today with the final set of the jury instructions you would have over the weekend to prepare your closing arguments. I previously emailed each side preliminary jury instructions, but if you don't have them, we got a paper copy.
Thank you.
There you go. State, do you need a paper copy?
I have.
Okay.
Okay. Did the court receive our motion?
Yeah, I'll get to that.
Thank you.
I'll just take them in order. I know that the defense did file yesterday, June 22nd, a motion to include additional jury instruction regarding the definition of a caregiver. I'll just handle it like any other charge conference. Each side's got the instructions in front of them. We'll just go one page at a time, one instruction at a time. I'll ask either side if you have any objections or any additional requests, anything that needs to be changed. If you bear with me 1 minute, I will print out a new version of it and give it to you so you can leave here today with what the final instructions would be. So, 2.7, the introduction to closing arguments. It's not going to be included because I'm going to read that to the jurors before the closing arguments. So the first one after that will be 3.1, introduction to final instructions. I will read the standard instruction in its entirety. State any objection.
No, Your Honor.
Defense, any objection.
No, Your Honor.
I'm then going to read 3.2, statement of charge as follows. Scot Peterson, the defendant in this case, has been accused of the crimes of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. Culpable negligence, culpable negligence, culpable negligence, and perjury not in an official proceeding. State any objection.
No, Your Honor.
Defense, any objection.
No, Your Honor.
I'm then going to read 16.5, neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. This relates us to count 1 as follows. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Anthony Borges with the care, supervision, and services necessary to maintain Anthony Borges' physical or mental health, or Scot Peterson failed to make reasonable effort to protect Anthony Borges from abuse, neglect, or exploitation by another person. 2, in doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Anthony Borges. 3, Scot Peterson was a caregiver for Anthony Borges. 4, Anthony Borges was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. State any objection.
No, Your Honor.
Defense, any objection.
No, Your Honor.
Well, let me rule on your pending motion. This is where you want me to start substituting. You've requested the additional definition of caregiver out of 39.01, correct?
That's correct, Your Honor.
You want me to include that in all of the neglect of a child instruction?
Yes, Your Honor.
State your position on the defense request that I would include additional language from the standard instruction using the definition of caregiver in 39.01.
The state would be objecting, Your Honor, relying upon, as Mr. Klinger stated, Stacey Christie, which is 939 Southern 2nd 1078. State v. Nowlin, which is 57. Oh, I'm sorry, Nowlin, Nowlin, 50 Southern 3rd 79. Grady, which is 111 Southern 3rd 810, as well as the Durand case, which I have to get the site, Your Honor. Your Honor, I can supplement, I can find that. But yes, the state would object to this, Your Honor. It's actually been promulgated through the cases that 827.03, as it stands, the jury instruction with the language of or any other person responsible for welfare is the standard jury instruction, should be the jury instruction for child neglect cases. Chapter 39, as defense is requesting, is a completely separate chapter. It has to do with completely separate allegations, more along the lines of DCF investigations and when law enforcement shows up and that they're not responsible if they don't do what's necessary. These particular cases say that you don't have to look at those two different chapters in parallel altogether, and that they're separate, and that this specific cases say that the jury instructions that should be utilized when this count is put forth before by the state is the jury instruction that are promulgated by the Florida Supreme Court, just as you put together, Your Honor. And as such, the state would be objecting to including 39.
Okay.
Oh, and for Duran, it's 820 Southern 2nd, 381.
Okay, well, actually, I think it's in the language expressly in Christie, and I think it's referenced in the other cases, but Chapter 39 has to do with dependency proceedings. That gives a definition for caregiver. Chapter 827, which is what the state's traveling under in this case, 827.01 gives us definition of caregiver. That's the definition that the Supreme Court has included in the standard instruction. So over the defense objection, which would otherwise be preserved as to each of those counts, I'm not going to give the additional definition of caregiver. We're going to stick with 827.01, which is what the legislature included in the chapter that includes neglect of a child. But that's over the defense objection, which is otherwise preserved. Defense, any additional objection as to the definition, neglect of a child, is to count one. Okay. So count 2 is verbatim the exact same language as count 1. I will read 16.5 again. The only difference is Anthony Borges' name is removed and replaced with Kara Loughran. Besides that, the instruction is otherwise identical. State, any objection?
No.
Defense, any additional objection?
Well, I have a suggestion.
Yes.
Does the court have to read all 7 counts, the exact same language, back to back to back? Can we come up with a way to say it's identical except for in number 3, it's a different victim? Why read 7 full pages of instructions to the jury, especially when they're going to likely get a copy of it?
Well, they are going to get it. Each one of them will have a copy of this. What is your request? What do you want me to do?
My request is that the court reads it one time, and the additional 6 counts, the only difference is that the number 3, the only change is number 3, and then you read in second count, Scot Peterson is a caregiver for Kara Loughran. It's alleged that Scot Peterson is a caregiver for Joaquin Oliver, and you just read the only difference. No reason to read 7 full pages of the same exact language.
State your position on the defense request that I somehow abbreviate the standard instructions.
Again, Your Honor, I'm certainly not making the court have to go through extra work, but I do believe, and I do object, the court needs to read all the counts in their entirety to the jury.
Yeah, okay. Over the defense objection, which is otherwise preserved, I'll read each standard instruction as it's printed. Defense, any additional objection?
No, Your Honor.
All right.
It is Loughran.
I was just going on, I think someone told me that was how her name was pronounced.
Kara Loughran, not
Loughran.
Yes, I mispronounced it.
Okay.
Yeah, that's
Hold on.
all Judge.
And my motion to include a definition that we have provided that we believe defines precisely what a caregiver is, which excludes law enforcement, I'm requesting that be read for each and every of the 7 counts.
Yeah, no. I consider that preserved. That's you've made that same request as to counts 1 through 7. I consider it to be a contemporaneous objection and preserved as to each. All right, so that's count 2. Then I'm going to read 16.5, neglect of a child, with the name Joaquin Oliver. The other verbatim instruction will be read as is. State any objection?
No, Your Honor.
Defense, any additional objections besides the 2, which I will consider renewed at this
No,
time?
Your Honor.
All right, as to count 4, I'll read 16.5. Kyle Lehman.
No objection.
Defense, besides the 2 objections which are otherwise preserved, any additional objection?
No, Your Honor.
I'm then going to read 16.5 as to Jamie Guttenberg, the other part of the verbatim instruction identical. State, any objection? Defense, besides your two objections which are otherwise preserved, any additional objection?
No, Your Honor.
I'm then going to read 16.5, Peter Wang, otherwise the verbatim instruction.
No objection.
Defense, besides the two objections which you have preserved, any additional objection?
No, Your Honor.
I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, as follows. To prove the crime of neglect of a child, the state must prove the following three elements beyond a reasonable doubt. 1. Scot Peterson willfully or by culpable negligence failed or omitted to provide Marian Kabachenko with the care, supervision, and services necessary to maintain Marian Kabachenko's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Marian Kabachenko from abuse, neglect, or exploitation by another person. 2. Scot Peterson was a caregiver for Marian Kabachenko. 3. Marian Kabachenko was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. State, any objection?
No.
Defense, besides your two objections which are otherwise preserved, any additional objection?
No, Your Honor.
May I just want to interject, and I don't have an objection, because I've always believed that the court should read the standard jury instructions as they are given from the Supreme Court. I just, for the record, would note that the definition of culpable negligence given for the child neglect count is slightly different from the definition of culpable negligence given.
You are correct. It is slightly different.
So, however, that said, like I told you, I have always been one who believes in following the Supreme Court's jury instructions and not changing them. So, I thought I would just point that out.
Yes, I noted that myself, but thank you for pointing it out. That's what I'm going to read. Okay, next, the next count, I'm going to read 8.9, culpable negligence, as follows. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Scott Beagle to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. State, any objection?
No. No, Your Honor.
Defense, any objection?
No, but I did want to renew a very specific motion, Judge. I was focused so much on the felonies that I didn't look at the culpable negligence as closely. There is zero evidence that the state proved that my client exposed anyone, especially Scott Beagle, Stacy Lapel, and Meadow Pollock, to personal injury. This is not omission in this statute. We're talking about he exposed these three people to personal injury.
Well, yeah, I mean, you're going to say he didn't, and the state's going to say he did by either what he didn't do or what he did do, but again, that's a jury determination.
Well, in the felony, it talks about omitted, that negligence, by culpable negligence failed or omitted. There's the omission language in there. In this culpable negligence, it says exposed him to personal injury. There's no element that says by omission. So the question is, how did the state prove that my client intentionally exposed anyone to personal injury?
Well, it doesn't say intentionally.
Okay, he exposed. How do they prove that he exposed?
I'm quite sure that they're going to talk about that in their closing argument quite a bit, just like you can talk about it in your closing argument that they didn't. But if you're making that part of a renewed motion for judgment of acquittal, I'll consider that part of your argument. I'll stick with the same ruling. Respectfully, it's denied. There's ample evidence, I guess, that the jury could find that he exposed Scott Beagle to personal injury, or they may find that he didn't do anything to expose him to personal injury. But that's going to be their decision. So over your objection. Okay, the next, I'm going to read 8.9. It's the exact same verbatim instruction, culpable negligence, except with Stacy Lapel. State, any objection?
No objection, Your Honor.
Defense, any additional objection?
No addition.
I'm then going to read 8.9, culpable negligence, the exact same verbatim instruction, except with Meadow Pollock. State, any objection?
No objection.
Defense, any additional objection?
No, Your Honor.
I'm then going to read 18.1, perjury, not an official proceeding, as follows. To prove the crime of perjury not in an official proceeding, the state must prove the following 5 elements beyond a reasonable doubt. 1, Scot Peterson took an oath or otherwise affirmed that he was obligated by conscience or by law to speak the truth during a sworn statement. 2, the oath or affirmation was made to Broward Sheriff's Detectives John Curcio and Jeffrey Curtis. 3, Scot Peterson, while under oath, made the statement. Question, okay, all right, once you get closer and you hear those guys, how many rounds do you think you heard? Answer, it wasn't many. 2, 3. Question, okay. Answer, so I'm right there, I'm on the radio, I can hear the units coming, and the next thing while I'm keeping an eye on the door in the building, no shots, nothing anymore, it's quiet. Question, all right, what happens from there? Answer, and he, Officer Tim Burton, runs up by the tree, and I'm just telling him, you know what I heard. I heard a couple of shots, haven't heard anything since, and he's just taking cover by, behind the tree. I'm taking cover here, and units are now starting, no more gunshots, and units are starting to come in. Question, okay, now, did you ever see, while everybody is starting to arrive, did you ever see any of the students leave Building 12 at all? Answer, yes. Question, which were they all the doors, or answer, no. They were evacuating, and they were telling them they were taken out, and the kids were going out toward the parking lot. Question, okay, but that's when officers, answer, when the officers came. Question, inaudible. Answer, but we didn't see any kids. No. When I was on the scene there were no individual kids running out. None. Question, okay, so there was no kids that ran out to say to you guys, hey, there's a guy up there or anything of that? Answer, no. Question, you didn't see any kids until people started being evacuated by the police? Answer, yes. 4, the statement was false. 5, Scot Peterson did not believe the statement was true when he made it. Knowledge of the materiality of the statement is not an element of this crime, and the defendant's mistaken belief that his statement was not material is not a defense to the charge. State, any objection?
No, Your Honor.
Defense, any objection?
No.
All right, next I'm going to read 3.4 when there are lesser included crimes or attempts as follows. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusations have not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement are neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, and culpable negligence. The lesser crime indicated in the definition of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement is culpable negligence. State, any objection?
No, Your Honor.
Defense, any objection?
Is the court going to necessarily read lessers regardless of whether we want them or not?
Well, I'm asking if you have any objections. That's what I'm asking.
Okay. I just didn't know if, I can have a discussion with my client, we haven't discussed it yet, but is the court
Now's the
regardless?
time to discuss it, sir.
What's that?
This is the charge conference. Now's the time to discuss it.
Is it an option, before I talk with my client, the court, if we didn't want them, would the court consider not including the lessers?
Well, (16.5) neglect of a child, the second-degree felony, has 3 Category 1 mandatory lesser-included offenses, which is 16.6, child neglect without great bodily harm, permanent disability, or permanent disfigurement, culpable negligence, and culpable negligence, which are both 8.9. There are no Category 2 permissive lesser-included offenses. Your request is you don't want any lesser offenses.
I'm discussing with my client, I just didn't know if the court was inclined to entertain that motion, so.
I'm inclined to entertain whatever you would like to tell me.
Okay. We'll request them, I guess.
All right. Well, I think the case law says if either side wants them, they're mandatory. I'm supposed to give it, even if both sides said no, if I find that there's evidence of them, I'm still supposed to give it, but you're telling me you want me to give them anyway, so. The lesser included for all 6 counts of neglect of a child with great bodily harm, permanent disability, and permanent disfigurement. I'm also going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. I will likewise read culpable negligence as a lesser included offense for those 7 counts.
Your Honor.
Yes, sir.
I would, just one of them is not necessary. The neglect of a child without great bodily harm, we pretty much stipulated to that. I don't think it would be intellectually honest for them to even come back on that, absent some type of compromise, and that's not what we're looking for. So that count should not be read.
So what do you not want? What is your request, sir?
That you do not read the lesser included offense of neglect of a child without great bodily harm.
Okay. State your position on the defense request.
We want them read.
Okay. Well, again, understanding the case law tells me if the mandatory Category 1 lesser included offense, if either side requests it, and I think there's evidence to support it, there's certainly evidence to support it. So over the defense objection, I will grant the state's request. Those will be included as mandatory Category 1 lesser included offense. All right, I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. The exact same 16.6 verbatim instruction I previously read, except now will be with Anthony Borges. State, any objection?
No, Your Honor.
Defense, besides your 3 objections, which I consider renewed and contemporaneous, any additional objection?
No, Your Honor.
I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. The verbatim instruction for Kara Logren. State, any objection?
No, Your Honor.
Defense, any additional objection besides the 3 which are already preserved?
No, Your Honor.
I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement for Joaquin Oliver. State, any objection?
No objection.
Defense, besides the 3 objections already preserved, any additional objection?
No, Your Honor.
I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement for Kyle Lehman. State, any objection?
No objection.
Defense, besides the 3 objections that are already preserved, any additional
No,
objection?
Your Honor.
I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, Jamie Gutenberg. State, any objection? Defense, besides the 3 objections already raised and preserved, any additional objection?
No, Your Honor.
I'm then going to read 16.6, neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, Peter Wang. State, any objection?
No objection.
Defense, besides the 3 objections already raised and preserved, any additional objection?
No, Your Honor.
Right. I'm then going to read 8.9, Culpable negligence, the same culpable negligence instruction that I previously read, except it will be for Anthony Borges. State any objection.
No objection.
Defense any additional objection.
No, Your Honor.
I will then read 8.9, culpable negligence for Kara Logren. State any objection.
No objection.
Defense any additional objection.
No, Your Honor.
I will then read 8.9, culpable negligence, Joaquin Oliver. State any objection.
No, Your Honor.
Defense any additional objection.
No, Your Honor.
I will then read 8.9, culpable negligence, Kyle Lehman. State any objection.
No, Your Honor.
Defense any additional objection.
No, Your Honor.
I will then read culpable negligence, 8.9, Jamie Gutenberg. State any objection.
No, Your Honor.
Defense any additional objection.
No, Your Honor.
I will then read culpable negligence, 8.9, Peter Wang. State any objection.
No objection.
Defense any additional objection.
Your Honor.
No?
No.
Okay. I'm then going to read 8.9, culpable negligence, Marian Kabachenko. State any objection.
No objection.
Defense any additional
No,
objection.
Your Honor.
All right, then I'm going to read 3.7, plea of not guilty, reasonable doubt, and burden of proof. I will read the standard instruction in its entirety. State any objection.
No objection.
Defense any objection.
No.
I'm then going to read 3.9, weighing the evidence. This one will have to be edited in some form or fashion. I always read paragraphs 1, 2, 3, 4, and 5. State, let me ask you first, are you requesting that I read paragraphs 6, 7, 8, 9, or 10?
Not 6, Your Honor. Not 7. I think 8 applies, Your Honor. No to 9 and no to 10.
All right, defense, the state's asking me to read paragraphs 1 through 5 as well as number 8. Are you requesting 6, 7, 9, or 10?
No.
Okay, so I'll take out 6, 7, 9, and 10. They'll be renumbered paragraphs 1 through 6. I will then read the remaining paragraphs on the bottom of that page, including the bottom paragraph, which starts with expert witnesses, or like other witnesses, we did have expert testimony. Going on to the second page, the first full paragraph on the second page talks about accomplice or co-defendant testimony. I don't think we had any of that. State, any objection if I take that out?
No, Your Honor.
Defense, any objection if I take that out?
No, Your Honor.
The next paragraph talks about the testimony of a child. I don't think we had any child testimony. State, any objection if I take that out?
No, Your Honor.
Defense, any objection if I take that out?
No, Your Honor.
The next paragraph talks about the defendant becoming a witness. The defendant is not going to be a witness in the case. State, any objection if I take that out?
No, Your Honor.
Defense, any objection?
No.
And then the last two paragraphs will stay in as part of the standard instruction. If you give me one moment, I will give you a amended version of 3.9. All right, State, any objection to the amended 3.9?
No, Your Honor.
Defense, any objection to the amended 3.9?
No, Your Honor.
All right, I'm then going to read 3.9A, defendant not testifying, the standard instruction in its entirety. State, any objection?
No, Your Honor.
Defense, any objection?
No, Your Honor.
3.9B, defendant statements. There are statements alleged to be made by the defendant outside the presence of the jury. Defense, I'll ask you if you want me to read the standard instruction in its entirety. I will be more than happy to do so.
We're waiting for the state, right?
No, I'm asking you
Oh.
first. What do you,
I'm sorry.
if you want me to read it, I'll read it.
No, it's completely not relevant. We're not alleging that it doesn't apply, so no.
I mean, it's usually for interrogations of suspects, so.
Right.
State, the defense wants me to take out 3.9B. You have any objection to that request?
I do not.
Okay, so 3.9B will be out. I'm then going to read 3.10, rules for deliberation, the standard instruction in its entirety. The only change is I removed the paragraph that talks about questions that the jury asked that the witnesses were not allowed to answer because I don't let jurors ask questions. But besides that, it's the standard instruction. State, any objection?
No.
Defense, any objection?
No, Your Honor.
I'm then going to read 3.11, the cautionary instruction, the standard instruction in its entirety. State, any objection?
No.
Defense, any objection?
No, Your Honor.
I'm then going to read 3.12, verdict as follows. You may find the defendant guilty as charged, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. Putting aside the verdict forms momentarily, state, any objection to 3.12?
No, Your Honor.
Defense, any objection?
No, Your Honor.
I'm then going to read 3.12a, single defendant, multiple counts as follows. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. State, any objection?
No objection, Your Honor.
Defense, any objection?
No, Your Honor.
I'm then going to read 3.13, submitting the case to the jury, the standard instruction in its entirety. The next to last paragraph on the bottom, I have made the elections, so the paragraph reads as follows. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. State, any objection?
No objection.
Defense, any objection?
No, Your Honor.
And I know, State, in my normal courtroom, I would usually rely on you to get a clear laptop to go back to the jury room. I believe this jury room is equipped with that, has that equipment already.
I believe so as
It's
well.
one issue, Judge. So the external hard drive that has all of the surveillance is very difficult to navigate. And it's also password protected. So if the court wants, we can give the information to the deputy or to somebody. I'm not sure how we would either pass that information to them or if they have to come into the.
You're talking about State's Exhibit 5?
Yes, Your Honor.
Okay. Well, I'll think about that when this goes. So my inclination right off the top of my head would be I wouldn't say anything to the jury about it. We'll send everything back. If they have an issue, I'm sure they'll let me know that they're having an issue with trying to look at something. But let me think about that. I'm not going to authorize the deputies or anyone to have communication with the jurors outside of our presence. They're not going to do that. So let me think about that one for a little bit. Okay, so then after that, state, any objection to 13.13?
No.
Defense, any objection?
No, Your Honor.
All right, so then I have 11 verdict forms. 1 through 6 are identical. They read as follows. There's 4 choices. We, the jury, find as follows as the defendant in this case. Check only one. A, the defendant is guilty of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement as charged in the information. B, the defendant is guilty of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, a lesser included offense. C, the defendant is guilty of culpable negligence, a lesser included offense. D, the defendant is not guilty, and there's a place for the foreperson to print and sign their name. I have to change these so it says June instead of July. State, any objection?
No, Your Honor.
Defense, without waiving your prior objections as to the lesser includeds that you did or did not want contained therein, any objection to the verdict form?
No, Your Honor.
All right, so 1, 2, 3, 4, 5, and 6, those verdict forms are all identical. I will also be sending back with the jury a copy of the information, the charging document, so they can match those up. I'll have to change all these, which I'll do as soon as we're off the record today, so it says June instead of July at the bottom. Count 7. We, the jury, find as follows as the defendant in this case. Check only one. There are 3 choices. The defendant is guilty of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement as charged in the information. B, the defendant is guilty of culpable negligence, a lesser included offense. C, the defendant is not guilty. State, any objection?
No objection, Your Honor.
Defense, any objection?
No additional.
And then as to count 8, the verdict form is the same for 8, 9, and 10. They read as follows. We, the jury, find as follows as the defendant in this case. Check only one. A, the defendant is guilty of culpable negligence as charged in the information. B, the defendant is not guilty. And there's, of course, a place to date, print, and sign for the foreperson. State, any objection?
No objection.
Defense, any additional objection?
No, Your Honor.
All right, lastly, as to count 11, the verdict form has 2 choices. It reads as follows. We, the jury, find as follows as the defendant in this case. Check only one. A, the defendant is guilty of perjury, not in an official proceeding as charged in the information. B, the defendant is not guilty. And there's a place to date, print, and sign the name of the foreperson. State, any objection?
No objection.
Defense, any objection?
No, Your Honor.
Okay, so that's going to be the jury instructions. Again, all the defense objections and/or state requests, I'll stick with the same rulings. Those objections are all preserved and contemporaneous. Next, as far as time-wise on Monday, state, I'm thinking about maybe 90 minutes for closing. How's that sound?
Split it amongst us, Judge?
Yes.
No, Your Honor, we're requesting additional time.
How much are you asking for?
We're asking for a total between the 2 of us of 2 hours.
2 hours. Okay, Mr. Aguilar, you think you can do it in 2 hours?
I haven't finished writing, so I can't tell you with certainty how long it's going to be, Judge. It won't be more than 3 hours. You just set a 3-hour cap. I don't want to worry about.
Your request is 3 hours?
It's not. I don't believe that I'm going to speak for that long, Judge, but I definitely don't want to be looking at my watch.
Well, let me preface it by saying this, and I can press pause, and I can give you a final decision Monday morning if that's what y'all will choose. But in every first-degree murder case that I've ever presided over, including death penalty cases, I have never given more than 2 hours. 2 hours would be the absolute maximum. So the state's asking for 2 hours. If you're asking for more than 2 hours, I would probably deny that request. It would be preserved, and I'll give you the 2 hours. But I don't think it's fair to, I'll send the jurors out for restroom breaks in between, but to break up the arguments over the lunch break, I just don't think that that's fair. I think all the closings have to be given in one shot.
I never intend to speak any longer than necessary to cover all the issues,
Sure.
and I very well may be way short of that kind of time.
Mm-hmm.
I definitely don't want to have to be looking at my watch, and I still have new material. Again, I still haven't written everything yet, so I just
I understand.
Really have time.
So I'm going to say 2 hours now. You both can renew, both sides can renew whatever request you might have Monday morning. State, who's giving the initial closing argument for the state?
I am, Judge.
Ms. Gomes. And then who's giving the rebuttal argument for the state?
I am, Your Honor.
Ms. Gomes, let's say it's 2 hours. How do you want to divide that up?
Judge, I don't believe that I'll go the entire time, but an hour and 15 for me.
You want 75 minutes?
Yes, please.
Okay. And then would you like some type of warning as you're approaching the 75 minutes?
Yes, I'd like a 5-minute warning. And Judge, can I ask for an additional 1-minute warning if I'm still talking? But
As many as you would like. That's better than my call. Okay, so once you get to 70 minutes, and then once you get to 74, I'll give you a tap. If you exceed the 75 minutes, I'm not going to stop you. Whatever is remaining, that would be the time remaining for the state's rebuttal argument. Okay, and I'll write that down on a Post-it note and tell you the time. Mr. Igarsh, regarding your 2 hours, let's just say it's 2 hours, but I'm not foreclosing myself to entertain anything further. I can give you one or multiple warnings. Would you like me to do that at any point in time?
Well, there's 10 minutes.
Just 10 minutes?
That's it.
And that's it? All right, so again, at 10 minutes, I'll give you one of those. If either side reaches their allotted time, I'm not going to cut you off in mid-sentence. When you get done making your point, I'll tell you that I'm going to need your final word at that point because your time has expired. State, is there anything else that you need me to address before we recess the trial until Monday morning?
No, Your Honor.
Defense, anything else you need me to address?
No, Your Honor.
So I would also ask you all, I know we're going to try to get started a little earlier, but if anyone's putting anything up in their closing, obviously anything that's in evidence can be up in the closing, but if you're going to put something else up in additional as part of your presentation, which you're certainly entitled to do, if you'll just show the other side, in case there's any objections from either side, I can rule on those in a timely manner, and we can get going in a timely manner on Monday.
Your Honor?
Yes, sir.
I know that I'm going to be showing a PowerPoint, and there was technology in opening that was there. It was a device that I can put onto my computer.
Okay. I can make that
don't see
same
it.
request.
Can we make that available?
Yeah, Mr. Svitz, you got it?
I believe it's in your desk up there. It's a little dongle. It's a wireless device that can transmit to the monitors.
Not my desk.
Well, the chief judge's desk.
Is this?
Yep, that's it.
Okay,
Yep.
all right, yeah, we can get that set up for you. Not a problem.
Thank you, Judge.
Defense, anything else?
No, Your Honor.
Okay. All right, so the trial then otherwise is going to be in recess until Monday, June 26th at 9:15 a.m. Division FX will be in recess until Monday, June 26th at 8:45 a.m. I hope you all have a good rest of your afternoon. I'll see you Monday morning.
Have a good weekend.
All right, Madam Court Reporter, that is it.